RM09 would be going for finals. Please rise up. Yeah. Congratulations. Second team, which goes to final, RNM21. Congratulations, both of you, and congratulations to all the teams. Good luck. Thank you.
Congratulations to all the qualified teams. Now we'll be doing the draw of lots for the final rounds. One member from each team, please come forward. So we have petitioner on one chit and respondent on one chit. You can both pick one chit. RNM09 as petitioner, RNM21 as respondents. Congratulations.
Hello.
Hello.
I am taking this team with me. Sorry.
Hello.
Hello, hello. My test. हेलो चेक
हम एक से ही बोल देंगे। अच्छा क्या ना ऑलरेडी आ गए। दो है तो दो दे दो भैया। इधर ही होना है ना मैं खड़ा। इधर ही होना है ना मैं खड़ा।
हाँ फाइनल राउंड्स के लिए अनाउंसमेंट तुम ही कर रहे हो ना।
नहीं मर्सी मैम मुझे नहीं पता पहले वो उन्होंने हमें ये बोला मर्सी के साथ अबे वो बाद में फाइनल राउंड अभी हैं।
फेलिसिटेशन के लिए तो तुम बोलोगे ना कौन कर रहा है फेलिसिटेशन।
अडीन मैम नहीं आई ना पहले अपेक्षा मर्सी मैम और अच्छे से पक्का हाँ डीन मैम ये पीएसी मैम नहीं है। Guys, please settle down everyone. The guests are about to arrive.
ऐसे ही होगा सेकंड ये नीचे से होगा
Good afternoon, everyone. I request everyone to settle down, please. The judges are arriving. I repeat, I request everyone to please settle down. The judges are arriving. And please maintain silence in the moot court hall.
हेलो
हाँ ठीक है।
Good afternoon. Hello, hello, hello.
Hi guys, the judges will be here in any minute. Excuse me, attention everybody. The judges will be here any minute, so please maintain the decorum and take your seats. And please keep your phone on silent or DND. Please keep your phone on silent, everybody, and DND.
Good afternoon, everyone. It is our distinct honor and privilege to welcome the esteemed judges, learned members of the faculty, dedicated members of the organizing committee, and all distinguished individuals who grace us today for the final rounds of Law Center 1 First R.N. Mittal Memorial National Moot Court Competition 2026. Your presence not only elevates the stature of this competition, but also inspires every participant to strive for excellence, knowing that their arguments will be heard and assessed by such distinguished members of the judiciary. I am Vasudha.
And I am Suhani, and we are honored to welcome our esteemed guests, Honorable Ms. Justice Neena Bansal Krishna, Judge, High Court of Delhi, and Honorable Ms. Justice Manmeet Preetham Singh Arora, Judge, High Court of Delhi, who have graciously consented to adjudicate the final rounds of this moot court competition. We also have with us Honorable Ms. Justice Pratibha Rani. Ma'am, it's our privilege to have you here. We request everyone to please give a round of applause for our esteemed guests.
We now like to take a moment to acknowledge the immense honor of having such a distinguished panel with us today. Their presence truly enriches this occasion and inspires everyone gathered here. As a token of our deep respect and appreciation for their remarkable contributions, we now take the moment to formally felicitate our esteemed dignitaries.
We are deeply privileged to have with us the gracious presence of Honorable Ms. Justice Neena Bansal Krishna, Judge, High Court of Delhi. Ma'am is an alumnus of Faculty of Law and joined the Delhi Judicial Services in 1992. Later, she got promoted to the Higher Judicial Services in 2003. It's an honor to have you here, ma'am.
It is now a distinct honor to welcome Honorable Ms. Justice Manmeet Preetham Singh Arora, Judge, High Court of Delhi. We would like to take this opportunity to highlight that the artwork that has been presented here has been meticulously crafted by remarkably talented, specially able children of the Parivartan Foundation.
We are also graced by the presence of Honorable Ms. Justice Pratibha Rani. Ma'am, it's a privilege to have you here with us. May I request Dr. Akshay Kumar, Assistant Professor at Faculty of Law, along with Ms. Sakshi Mendirata to felicitate ma'am. Ma'am, it's an honor to have you here. We are deeply grateful to your ladyships for taking out the time from your demanding schedules to be with us today for guiding young aspiring members of the legal fraternity. From here on, we request Dr. Mercy K. Khaute, co-convener of Moot Society, to take over. Ma'am, please.
Good afternoon, everyone, and congratulations to the team that has gone into the final rounds. To maintain the decorum of the court, may I request each of you to find a seat and please settle down. During the proceedings, switch off your phones or please keep them in the D&D mode. And I wish the teams the very best, and we are grateful that we have been able to see this day. So I now hand over the proceedings to the court master.
Afternoon, everyone. My name is Sangeeta Shukla, and I will be the speaking court master for this round.
And my name is Shivam Kanoja. I will be the communication coachmaster for this round.
It gives me immense pleasure to welcome you all for the first edition of R.N. Mittal Memorial National Moot Court Competition, organized by Law Center 1 Faculty of Law. Now, I would like to thank the judges for giving us their time and valuable presence. For everyone's convenience, now I would tell the time allocation given to each team. So we have RNM 09 with us representing the petitioner, and RNM 21 with us representing the respondent. So the time allocation is as follows. For RNM 09, Speaker 1 has been allotted 20 minutes, Speaker 2 has been allotted 19 minutes, and they have reserved 6 minutes for rebuttals. Am I correct? For RNM 21, Speaker 1 has been allotted 21 minutes, Speaker 2 has been allotted 21 minutes. Am I correct? With the due permission of the benches, we shall now proceed with the proceedings.
The council seeks permission to address the benches, your ladyships. The council seeks permission to submit our... with your ladyships' permission, the council seeks permission to appraise your ladyships on the facts of the case. Your ladyship, the present matter arises out of a real estate development project known as Celestial Heights, undertaken by Skyline developers pursuant to agreements entered with various home buyers, which started in 2015. The project, like many large-scale real estate ventures, encountered significant delays and financial difficulties, resulting in its inability to adhere to the originally stipulated timeline for the completion of the project. As a consequence, multiple home buyers initiated proceedings before the appropriate forums. They invoked their arbitration clause in the sale of agreement. They approached the RERA authority seeking remedies such as refund, compensation, and enforcement of contractual obligations. These forums have already been adjudicated and actively seized the disputes, and civil consequences arising from the project have been extensively adjudicated. Subsequently, insolvency proceedings were also initiated against the company under the applicable insolvency framework, further indicating the financial distress and commercial failure of the enterprise rather than any criminal design. It is this background we submit after the invocation of multiple civil and statutory remedies that the present FIR came to be registered with the CBI, alleging offenses such as cheating, criminal breach of trust, and forgery against the petitioners who are directors of the company. The petitioners humbly submit that the allegations arise entirely out of contractual obligations and alleged non-performance and do not disclose any elements of criminal intent at inception. The dispute essentially concerns delays, financial mismanagement, and business failures, which are matters squarely within the domain of civil and regulatory law. That the initiation of criminal proceeding, therefore, constitutes an attempt to convert a purely civil dispute into criminal prosecution. Your ladyships and may it please the court. This court has framed 4 issues in the current matter. The first 2 issues deals with the quashing of FIR, and the third and the fourth issue deal respectively about section 14 of IBC moratorium as well as personality rights. Me along with my co-counsels will be representing the petitioners who are the directors of the company. I'll be representing and presenting arguments for issue 1 and 2, which is quashing of FIR, and my co-counsel will be representing issue 3 and issue 4. Your ladyship, issue 1 and issue 2 are severely interconnected. Because in issue 1, this court asks a question about if there is an abuse of process because the home buyers have invoked various civil remedies. In issue 2, they ask a question about if there is a prima facie case or prima facie ingredients which must be present to attract the alleged crimes which are present in the FIR. For the convenience of argument, I would like to address issue 2 first and issue 1. And the reason behind that is that this court in 1992, in its landmark judgment of State of Haryana versus Bajjanlal, laid down 7 categories the High Court and this Honorable Court can invoke to quash any FIR if it is an abuse of process. And the first category this court laid down was the absence of any prima facie ingredients present in the FIR, or if there is no evidence which can substantiate that there is prima facie allegations present. Because of that, I'll be addressing issue 2, and then I'll be moving on to issue 1 with your ladyship's permission. Much obliged. Your ladyship, in issue 2, there are 3 crimes which are alleged against petitioners. Primarily, section 405, criminal breach of trust, 420, cheating, 467, 468, 471, forgery. I'll be taking up each allegation and proving to your ladyship that there is an absence of prima facie ingredient in each of these offenses, and due to that, there is no prima facie ingredient when the complaint is read as a whole. With your ladyship's permission, I'll be addressing.
One question.
Yes, your ladyship.
Do these sections still exist? 406, 471, 420, or has the statute been replaced?
Your ladyship, we agree with your ladyship that the BNS replaced the IPC.
What are the corresponding sections?
We were asked to adjudicate on the IPC sections from the, it was presented in the issues that we were supposed to adjudicate on the IPC sections. The first allegation made against the petitioners is section 420, which is cheating. This court, in various cases, while examining if cases pertaining to section 420, has laid down that the prima facie ingredient which must be present for attraction of 420 is dishonest or fraudulent intent by the accused at the inception of the business. That is the prima facie ingredient this court examines sitting while quashing the petition proceedings. We submit to this court that the accused did not have any dishonest or fraudulent intention at the very inception of the business between the home buyers and the petitioners. Your ladyship, we rely on Hridyaranjan Prasad Verma versus State of Bihar in our compendium marked as 16, flag 16, as well as in Visa Holdings versus State of Kerala, where this court has laid down the prima facie ingredient is dishonest intention from inception, as in from the very beginning of the business. Your ladyship, the facts of the case tell a different story, that there was no intention from the very beginning. As this, the RERA Act came into force from 2016. The business started in 2015. As soon as the RERA Act came, the businesses registered with the RERA regulations, registered their business with RERA registration, complied with RERA regulations. Secondly, they also demonstrate by seeking approval of building planning approval as well as environmental clearances, respectively in March 2016 and July 2016, regarding and following all RERA regulations. The allegations made here do not disclose that the petitioner here, only the petitioners here are the directors of the company, do not have any intention, and there is nothing on the evidence that they had an intention to cheat or cause any fraudulent activity with the home buyers from the inception of the contractual business. There is nothing in the evidence or in the FIR which shows that there was an inception from the very beginning. We submit that the mere failure to keep a promise by the company, not even by the directors, should not subsequently, and it should not prove that dishonest intention at the beginning, and this is the trait of the law we are presenting. Your Leadership, the second allegation brought was section 406. Before I move on to section 406, I would like to highlight one law this court has said over and over again, that any FIR which contains 406 and 420 cannot exist with each other because they are exclusive of each other. And the court has explained in these judgments that 406 requires, or the prima facie ingredient in 406 is an intention to fraud or commit fraud from the very beginning of the business. Whereas 420 reveals that the intention from inception. I apologize. 406, the prima facie ingredient required is that there must be an entrustment of property, and later in the course of time, the property which has been entrusted must be utilized for the purposes it was not intended to. So this court has laid down that 406 and 420 cannot coexist with each other because they contradict each other. One of them claims that the intention and the crime was committed at the inception itself. The other one claims that the crime was committed subsequently and the intended is released subsequently. We are relying here on the landmark judgment of Delhi Race Club versus State of Uttar Pradesh, where this honorable court has laid down that they are exclusive of each other. Your Ladyship.
My one question is, you said that the dishonest or the fraudulent intention for an offense of cheating has to be at the commencement of the offense. Does the rule apply even where the offense is a continuing offense? This act was a continuing offense. Secondly, you said there is no evidence of any kind of misappropriation. The facts say that the forensic audit found that in June 15, 2016, 25 crores were transferred to shell companies. So how would you say that there is no fraudulent intention or there was no misappropriation? Yes.
Yes, Your Ladyship. When this court sits at this juncture of examining if there are prima facie evidence, with the diversion of funds, Your Ladyship, I'm pretty sure is talking about entrustment of funds as a property, and then they diverted it to other shell companies. Am I right, Your Ladyship? Absolutely. With the entrustment happens, the court in 406, while examining prima facie, has said there are two ingredients. One, there must be entrustment of the property. It can be non-movable property too. Second, the property must be used for the purposes it is not intended to. Even if we agree with the CBI about the diversion of funds, and I concede to the court, even if there is diversion of funds, there is only diversion of funds and nothing in the evidence proves that the diverted fund was used. The prima facie ingredients are very clear, that the entrusted property must be used for the purposes it was not intended to. As said in the facts, this was a company which was going through a lot of financial troubles. Due to that, there might be moving of funds from one account to another, which is a usual activity. But I would bow down my head before the court if the shell companies or the people who had access to the shell companies had used these funds. But that is not what has happened here. There is nothing in the evidence or in the FIR which shows that the funds were used. They were diverted, sure. but they were not used, which would not attract. The diversion of fund, your ladyship, at most would attract a RERA regulation violation, which says that the 70% escrow must be, 70% of the funds must be kept in escrow accounts. That is a civil regulatory adjudication, which must be done in RERA courts and should not invoke 406. If your ladyship is satisfied with the answer, I'll move on. As I just said before, to attract 406, entrustment and use must be there. And I submitted to this honorable court, both of these are absent. Entrustment is present, but there is no use of the diverted funds. Thirdly, we would like to submit one submission here, which is vicarious liability of natural persons without specific act and criminal intent. Your ladyship's, this honorable court in Muqsad Syed versus State of Gujarat, if I can get your ladyship's attention to our compendium, it is marked as flag 25. Flag 25, your ladyship. This honorable court clearly said an individual can be accused along with the company only if there is sufficient evidence of active role coupled with criminal intent. Vicarious liability of directors cannot be imputed automatically. In the next case, in the same case, the honorable court has also said that if for the attraction of vicarious liability on the directors of company because of the company's alleged fraud, the sole test the court uses if there is an explicit mention of attraction of vicarious liability in the provision. The provision in the IPC here, 405, 420, as well as the forgery provisions, there is no mention of vicarious liability which can be attracted from the company to the directors. The law is very clear. You can only bring the case against the directors because of the company's mismanagement or alleged criminal activities, only if there are provisions explicitly mentioned about attracting the criminal actions. Finally, about my forgery submissions, the submissions to prove that there is no prima facie intent with forgery. Your ladyship, in the evidence, they claim that 3 documents were forged. Firstly, they claim that the progress report presented to RERA was forged. Secondly, they claim that the audited balance sheets were forged. And thirdly, they claim that the board resolution was forged. This court, when it has examined the case of evaluating prima facie intent when it comes to forgery cases, has said that has said one thing. Forgery does not mean changing the contents of a document. It means changing the authorship of the document. For this, we have relied on the case of Sheila Sebastian versus R. Javaraj, where the court held that the falsity must go to the identity of authorship, not merely to the contents. An offense of forgery cannot lie against a person who has not created the document. Your ladyship, the first allegation is made against the progress reports. Your ladyship, the progress reports were submitted by authorized company officers under an existing statutory obligation. Secondly, these are the company's own documents executed in the company's name by persons who are authorized to do. Even if we agree that there were forgery of contents on the progress report, the progress report was signed by the directors themselves. The directors have the authority to sign those documents. There is no forgery here because a person who did not have the authority did not sign it. The directors who have the authority have signed these documents. Secondly, in case of audited balance sheet, it is very pertinent for me to present to your ladyship. When it comes to audited balance sheets, the facts reveal one thing. The balance sheets or the audit was conducted by independent auditors. The independent auditors are also members to the FIR. From in the overall FIR, the independent auditors along with the directors are booked under the FIR. So the directors who are being prosecuted here, this court is sitting for the SLP of only the directors and not the independent auditors who created the audit sheets. Hence, that also does not attract because the directors were never involved in creation of audit sheets because there was another independent entity, the auditors, who created the audit sheet. Thirdly, they claim that the board resolution was forged. We submit that both the directors were members of the board and hence they signed it. we concede the fact that they might have backdated it, but they had the authority to sign the board resolution and they signed it. So this does not attract the allegation of forgery, because the prima facie essential test this court does when questioning the attraction of forgery, if there was a forgery of authorship, and in all these three evidences, it proves that the people who were authorized to sign a document did sign it, and that does not amount to forgery of authorship. Based on these three submissions, we have proved to the court, through my submission, that there is no prima facie elements or ingredients required to attract the criminal allegations made in the FIR. It can be 405, 420, or forgery. Because of the absence of prima facie ingredients, we invoke category 1 of Bajjanlal, where this court has said that absence of these would essentially will give a chance for the court to quash the FIR. Moving on to the first part of the first issue, which basically asks about the abuse of process. In the overall picture of abuse of process given by Bajjanlal.
Just wait. My question to you is,
Yes, Your Ladyship.
your entire argument is that a forgery is committed only when a document is said to be prepared by a person other than the one who's signing. You were saying it's only the identity of a person, if not correct, amounts to forgery.
Yes, Your Ladyship.
The contents, according to you, are immaterial. Even if I am signing a document, but I present false facts, would it not amount to forgery?
It would amount to forgery, Your Ladyship.
You
But
just
here,
now said it's only the identity of a person who's preparing the document. What about the contents? If the contents are false, would it be forgery or not?
I think I missed that one point, which is that the contents also amount to forgery. But in this case, the evidence presented by the CBI says that the directors signed these documents. That would amount to forgery. And nothing in the evidence shows that they changed the contents of the document. They said the directors signed the documents. Based on that, that attracts the forgery of authorship, and nothing in the evidence proved that the directors changed the contents of the documents. Hence, I provided that test and not forgery of contents, because there is no evidence to prove the forgery of contents in the case.
By showing that the authorization was of a backdated. That is the question the senior judge is asking you, that merely because the two individuals were otherwise directors, would it ratify a forged document which is purported to have been executed on a backdate? That is the forgery.
I have one submission to that, is that this is, I would like to submit that this is an internal company dispute which has been alleged, and it would be fair for the Companies Act to step in, and the people who made these allegations, especially the people who made these allegations, and the crime here has been committed not, one thing here, Your Lordship, the obligations here to the home buyers was to build their houses back. If there is a forgery of board resolution, the injured party is the members of the board or the company. And there is no obligation about board resolutions to the home buyers here. They are not directly affected by the home buyers. Let's assume a situation where the home buyers give money to a company.
Extended by a minute.
I'll just finish
by
this.
1 minute. Give him one more minute. No?
Let him complete.
Yeah.
I'll just finish this, Your Lordship.
Yes.
A situation where the home buyers give money to a company, the company diverts the funds elsewhere, but they finish building it, they give the house back. Now they completed the obligation against the home buyers, yes, but even if they directed it, if the home buyers come forward and say, oh, they diverted my money, this court would not recognize it because the contractual obligation is over. You presented your money to the company built your apartments and gave it back to you. The diversion of funds is a matter. The company has to step in of their directors taking steps they were not supposed to and file a case. What we are contending here is that there is no locus standi for the home buyers to step in and say the company internal matter was a problem for them because they did not have an obligation present here. Their obligation was contractual obligation in nature when they entered the agreement of sale.
All right, your time's up, but I just want to clarify to you that your submission in law is incorrect. You are treating your directors like partners, whereas your directors are actually in a fiduciary capacity and they could not have dealt with the funds of your company in the absence of an authorized board resolution. So I think your clients who you are representing had no legal or moral justification to create a board date antedate. But anyways, we've understood your point.
I apologize if it was like that.
All right.
Thank you, Ladyship. It was an honor, Admin.
Your Ladyship, I will be dealing with issues 3 and issues 4 respectively. Issue 3 concerning the extension of the moratorium under section 14 to the individual directors acting in capacity of the company, and issues 4 dealing with the hierarchy of adjudication when it comes to the personality rights claim made by the respondents in this matter during the CIRP, as well as if or if not the thought of misappropriation has been applied perfectly in this matter. Your Ladyships, if you notice in this specific complaint, you'll realize that the home buyers in this instance have only proceeded with the FIR post the CIRP, Your Ladyships. There were 5 months of space between instituting the allegations against the directors after the IRP was already in place. Your Ladyships, and after the IRP was already in place, since the IBC already provides protection for the corporate debtor under Section 14, the only other entity that the home buyers could have sued in this instance for their claims were the directors, Your Ladyship. Essentially what that means is they are trying to extort money in this instance, Your Ladyship. They are trying to blame the directors for acting within the capacity of the company. Your Ladyship, they are forcing them into a submission through the FIR to settle as soon as possible. And I will prove that to Your Ladyship. Essentially, if you look at Chawa's complaint to the CBI, Your Ladyship, you'll realize that there are 3 factual allegations, which were the diversion of home buyers' funds to shell companies, the fabrication of books of accounts, and the execution of the fraudulent board resolution. These 3 have already been established by my previous co-counsel, Your Ladyship. If we were to take what my previous co-counsel said, that any allegations in the FIR containing 406 and 420 are mutually exclusive and they cannot be conducted in proceeding with this. You'd also, Ladyship, even the test that he laid forward for the diversion of funds, where the 2 essentials are the extraction of the funds from the account, and the second one being the utilization of said funds for separate purposes. Ladyship, it's established here by my co-counsel that the first essential has been fulfilled, where they have extracted the money out of the preferred corporate accounts into separate corporate accounts. But they have not specified what it has been utilized for. It has primarily been transferred out of the account into a separate account, either by private holdings within each corporate entity holds, or separate holdings that were not even part of the company to begin with. Your Ladyship, continuing with this, the Honorable Court in Indian Oil Corporation versus NEPC India basically cautioned against the growing tendency of converting essentially what are civil matters into ones that might be criminal. Your Ladyship, you'll realize that the AIBC already provides a very structured remedial framework under sections 43, 45, and 66, through which the recovery and accountability process may be pursued for the benefit of all 1,500 home buyers, Your Ladyship. Besides this process being laid down, Your Ladyship, the arbitration clause within the sole agreement also very clearly states that it lays down a very clear measure or a framework for what dispute resolution is supposed to be approached in this matter. They have provided solely all litigation issues or any issue that arises with this contract to begin with to be proceeded with arbitration or to be taken into the local courts. Your Ladyship, when 200 home buyers have already proceeded with arbitration and are willing to wait for the IRP to complete before they can accept their claims, why is it that now the criminal proceedings are being initiated against the two directors specifically? That is the question at hand that must be addressed by the court and the respondents clearly. Your Ladyships, the award for the people that are going through the IRP resolution mechanism is 100% guaranteed to be awarded to them because they have followed procedural framework, and once the IRP comes to a resolution process, once the resolution process is complete and the resolution report is filed, Your Ladyship, the claims can be the unliquidated and liquidated claims from either the home buyers and other creditors in need of this can be claimed post-resolution process. Your Ladyship, that is impossible through the criminalization of the directors, mainly because the criminalization of the directors through the FIR basically creates a disruption. It creates a disruption to the IRP process. Your Ladyship, if you were to consider my humble submission, that vicarious liability in this instance cannot be attributed to the directors, particularly if you look at P. Mohanraj versus Shah brothers, you would realize that under Section 138 of the Negotiable Instruments Act, which is what this case deals with, they said that for the quasi-criminal provision to exist, it has to be aimed at the recovery of finances, Your Ladyship. So this would not only create a vicarious derivative liability upon persons under this section, but the court's observation in this matter basically creates a continuing liability that was made exclusively in the narrow context of the Negotiable Instruments Act. Your Ladyship, in this case, in this particular case, the appellants are facing charges which are not vicarious, neither are they derivative liabilities, but they are being accused of criminal intent from inception. Your Ladyship, if you look at the P. Mohanraj test as well, you'd realize the whole point of Section 14 in the IBC is to establish the moratorium as a going concern. It exists to create a shield to protect the corporate debtor's assets so it can be later utilized in the resolution process. Your Ladyship, they essentially said that the functionality test for Section 14 would be that the proceedings, any criminal proceedings or civil proceedings that arise from said resolution process should not result in the depletion of the corporate assets debtors within the moratorium period. Your Ladyship, if you were to apply that same test into this element, you'd realize that the prosecution of the directors in this instance, especially considering things like defense costs, whether direct or indirect, are a pecuniary attack on the matter. No, it extracts money from the asset depletion method that was already laid down in P. Mohanraj, Your Ladyship. So if you were to look at the company as a going concern, you'd realize that it creates not only a management, since there's already a management vacuum present, the presence of a FIR in the matter as well basically creates simultaneous pressure on these directors to settle as quickly as possible. Your Ladyships, even if you were to look at Section 32A, for example, of the IBC, Your Ladyship, you'll realize that Section 32A was extended to the corporate debtors to prevent them from being prosecuted under any criminal cases that may arise. Your Ladyship, this was added post the 2020 amendment to the IBC Act. Your Ladyship, in this matter, when there is already prevention of criminal prosecution for specifically the company or the corporate debtor at hand, if you were to apply Section 447 of the Companies Act as well, Your Ladyship, which is the punishment for fraud under the Companies Act, Your Ladyship, you will realize that the company and under Section 447, the company and every single person that is in charge and responsible for the conduct of the business of the company at the time shall be deemed guilty and present in the FIR and will have a trial against them. Your Ladyship, if you were to apply the principles of a joint trial to this matter, Your Ladyship, you'll realize that when two co-accused persons are present in a case, and one is legally incapacitated from facing the trial, which in this case, the corporate debtor is incapacitated because of Section 14 and Section 32A, protecting them and barring them from civil and criminal liability. Your Ladyship, so when a co-accused has been sort of invalidated from attending or being a part of the proceedings, then the court must either prosecute the directors separately, because the FIR is filed for both the company as well as the directors, or there must be specific allegations that can be attributed specifically to them. And at that similar moment, Your Ladyship, the court must assess whether the trial of the remaining accused can proceed independently without prejudice. Which in this matter, Your Ladyship, since the actions that were conducted were on behalf of the corporate natural persons acting in the capacity of the field of a director, it is impossible to proceed with a criminal case against these two individual directors without the company being a party to the case as well, without the company's presence not being in the party to the case, affecting the prejudice that it might have on individual natural persons, Your Ladyship. If Your Ladyship is satisfied with the arguments, I'd like to move on to issue 4. Wonderful, Your Ladyships. When it comes to issue 4, Your Ladyship, the two main arguments at hand are whether the utilization of the celebrity's face in this matter constitutes the tort of misappropriation or passing off, and whether the appropriate remedy, and what is the appropriate remedy and the hierarchy of adjudication, particularly when the corporate entity is under the CIRP. Your Ladyships, the present SLP at hand is arising from a criminal question. From a criminal question on whether or not the FIR should be quashed. Your Ladyship, the scope of these proceedings are purely criminal in nature. It is confined to this one specific criminal question. Your Ladyship, the personality rights claim, if you were to bring in the common law tort in this question, you are not only changing the entire purpose of the case into one of a civil nature, but you are rather depleting and turning the Supreme Court that we have approached into sort of a multi-pronged civil dispute channel, which is not the intention to begin with. Because, Your Ladyships, the celebrity civil suits are already pending before the District High Court of Viveknagar. They have exercised original jurisdiction and they have granted interim injunctions for the matter. Your Ladyship, it is contested that that court is the appropriate forum for determining the remedy specifically in the matter of personality rights. And Your Ladyships, at the same time, while that is happening, the moratorium under Section 14 already bars any and all civil proceedings against the corporate debtor. Your Ladyships, if the celebrities are claiming that there was the tort of misappropriation, the time or the essence of the particular time that they have chosen to initiate these proceedings have been during the course of the IRP. And during the course of the IRP, since the moratorium under Section 14 very clearly prohibits any and all civil proceedings from occurring against the company, it is contested that their claim to this remedy is untenable before the court. Your Ladyships, if you were to look at the case, the claims that the celebrities are making in regards to the tort of passing off, you'll realize that the...
I just have one question
yes, Your
for
Ladyship.
you. The facts which have led to the filing of the FIR against you, where can I find them in the paper book?
The facts that have led to the FIR, Your
In the
Ladyship.
Moot proposition, where are the facts which have led to the filing of the FIR against your client?
Your Ladyship, Moot proposition, paragraph number 10.
Paragraph number 10.
Yes, Your Ladyship. The CBI after
That
a
is the
preliminary...
FIR, but the allegations are at paragraph number 9.
Yes, Your Ladyship.
Where is the allegation pertaining to personality rights at paragraph number 9?
Your Ladyship, the issue is in... okay.
On a plain reading, I don't find that the misuse of the personality rights was the basis of the complaint at all. On the reading of paragraph 9.
Yes, Your Ladyship. Because
And even on paragraph 10, when CBI registers the FIR against you, I find no mention of personality rights.
True, Your Ladyship.
In fact, it appears that when you filed the SLP, you decided to make the actors a party over here.
Yes,
So
Your
why
Ladyship.
have you, in fact, presumed that there is a personality right issue at all in this FIR?
Your Ladyship, we didn't presume that there was a personality rights issue to begin with. We like to believe that the questions that have been provided for us to adjudicate in the matter were decided by the court in this issue.
But counsel, you can raise this issue that this issue does not arise for consideration because personality rights is not the subject matter of the FIR at all.
Yes, Your Ladyship. That's essentially what I held in my first argument, where the entire personality rights claim that the respondents are making is untenable before the court, mainly because we have filed it through an SLP petition, through a special leave petition, Your Ladyship. And the special leave petition is mainly to be dealt with criminal matters. So if you were to switch this thing and consider their argument or consider the case that they are putting forth before you, you are not only turning the element of the SLP from one that is purely criminal into a multi-pronged civil civil case leadership, but instead you are also creating way for you're laying precedents for way for multiple new generations or new issues that arise to come in through an SLP.
But you are the counsel for the petitioner. You have drafted the SLP and you have filed it.
Yes, Your Ladyship, but the actors in this matter were impleaded as necessary parties through the case. If you look at para 14 of the proposition, Your Ladyship.
Yes.
If you look at para 14 of the proposition, Your Ladyship, you will see that it says the, para 14, Your Ladyship, it says that the home buyers, Chava and the CBI are the contesting respondents, the resolution professional for Skyline as the corporate entity under CIRP, and the celebrities, Mr. Vikram Suryavanshi and Ms. Priya Rajawat, have also been impleaded as necessary parties given their vested interests in the outcome of the litigation. So they already have vested interests in the same, Your Ladyship, which is why they have been impleaded as necessary parties.
Okay.
Shall I continue with my arguments?
Yes.
Okay.
My one question is that personality rights we all recognize are civil rights,
Yes,
tortious liabilities. Can misuse or misrepresentation of a person to sell an article be also a criminal offense?
Can it be a criminal offense?
Doesn't matter, please continue.
No, Your Ladyship. To answer that question, Your Ladyship, I personally don't believe that it can be a criminal matter, mainly because unless you are misrepresenting or with the intention to commit fraud. But in this instance, Your Ladyship, the misrepresentation in the cases of celebrities stems from an issue of where the celebrities have sort of conflated the ideas of identifiability and misrepresentation. Because, Your Ladyship, the mere identification of the celebrity in the ad personally does not amount to misrepresentation.
As per the facts, they had never consented.
Yes, Your
Their
Ladyship.
images have been lifted and they have been, so is it not a fraud on the public that you pick up something and represent something which is absolutely incorrect? They have not endorsed the product. You are selling it by giving it a credibility of it being endorsed by a known celebrity and adding credibility to your project. Is it not a component of cheating and fraud?
Your Ladyship, for that, I would like to invoke the doctrine of caveat emptor, where if you were to realize that the Home Buyers Association are a group of parties that are essentially purchasing something of a very high value. Your Ladyship, according to jurisprudence, it is their duty to ensure that the contract that they're getting into is completely valid. They have to understand that the terms of the contract, it is on the duty of the consumer that is getting into it, Your Ladyship. So I believe that the homeowners had the duty to research into the matter and to realize that this was the issue. Besides that, Your Ladyship, the problem also arises from the fact that the celebrities waited before they approached a court or waited before they filed a cease and desist order. We had used even if the thought of misappropriation were to be true, the images were used back in 2015. The celebrities only approached for the case to be heard in 2020, where they had filed a cease and desist order, and we did not comply. We plead ignorance to that. But even though that happened, Your Ladyship, it is only then that they chose to initiate proceedings. They had 5 years worth of time to initiate proceedings, Your Ladyship. But suddenly, when the company is under the IRP and the directors are the only entity against which such proceedings can be initiated, is when they choose to initiate such proceedings.
Isn't there any limitation under the criminal law? Are they prevented in approaching the court or the criminal court after a certain number of years? Would the criminality get diluted by passage of time?
No, Your Ladyship, not at all. Okay. Your Ladyships, for the tort of misappropriation to be proved, there needs to be 3 circumstances that are proved, essentially. One is goodwill, the fact that the misrepresentation occurred, and the third one being the damages to the celebrities' reputations and so on and so such. Your Ladyship, the thought of misappropriation in this test is absolutely satisfied, if you were to take it as so. But Your Ladyship, the problem arises when the concept of goodwill and damages are taken into account. Your Ladyship, the celebrities at hand have not provided any evidence or anything of a substantial sort to prove that they have actually suffered damages from said misrepresentation. Your Ladyship, I would like to make...
One question.
If you... If Your Ladyships, let me continue for one more minute. Okay. Your Ladyships, to conclude, I would like to talk about the appropriate hierarchy of adjudication in this matter. Your Ladyships, since the injunctive component was already applied by the district court in the matter, the appropriate jurisdiction for this matter to be adjudicated, irrespective of the CIRP or not, is the district court. Mainly because they have already exercised original jurisdiction over the matter, and they have also filed for an interim injunction during the course of the CIRP, which post CIRP can be claimed, the claim for damages can be made. Your Ladyship, I would like to conclude with the prayer for the petitioner. Much obliged, Ladyship. Wherefore, in the lights of the facts presented, arguments advanced, and the authority cited, it is most humbly prayed that Your Ladyships allow the special leave petition and quash the FIR that is presented before you, along with all ancillary criminal and civil proceedings, as well as hold that the allegations made in the FIR, when accepted as true, do not contain the necessary ingredients of section 420, 406, 467, 468, and 471 under the APC, to declare that the moratorium provided for under section 14 of the AIBC constitutes a statutory bar and limits from civil proceedings and criminal proceedings from happening. At the same time, to declare that the personality rights of the respondents number 5 and 6 are not adjudicable within the scope of the criminal proceedings, and that any such adjudication must wait for the conclusion of the CIRP, and clarify that the hierarchy of adjudication sought by the respondents should exclusively remain through the statutory framework assigned to the district court, and pass any such order that this court may deem fit. So prayed.
Thank you. I just have one last question for you on your issue number 3.
Yes, Your Ladyship.
You yourself drew our attention to section 32 capital A of
Yes,
the
Your
IBC.
Ladyship. Yes, I did.
And you contended that since there's a moratorium applicable to the company, there should also be a moratorium against your petitioners. But isn't the proviso to section 32A1 actually accepting that? It is saying that no, even if the corporate debtor will not be prosecuted, your director will be.
Yes, Your Ladyship.
So then they are continuing correctly against you.
Yes, Your Ladyship, which is why I also brought up the fact that in regards to the FIR, since the FIR was filed against both the corporate debtor as well as the entity, if you were to apply 32's case to this specific matter, it protects the corporate debtor completely. So, Your Ladyship, when that happens, if you were to follow the jurisprudence relating to joint trials, if one person is untenable and unable to attend or make it a part of the proceedings that occur before the court, criminal proceedings, then the court should either hold a separate trial for both or conduct separate investigations for both, and at the same time, if it is possible, the case be dismissed altogether.
Okay. In the court's opinion, the statute is squarely against you and the law is also settled against you. So I don't think issue number 3 can be decided in your favor. Issue number 4, I think you're right, that the civil court will decide. But issue number 3, you have no grounds. Your SLP will not be allowed on that ground alone.
Much obliged, Your Ladyship. Thank you.
ठीक है मैम, आपको जैसा
Greetings to the bench. The council seeks permission to collectively address the bench as your ladyships. Much obliged. If it pleases your ladyships, I am the council appearing on behalf of the respondents. I'll be taking 21 minutes of the bench and my co-counsel will be taking 25 minutes of the bench. I'll be dealing with issue 1 and 2 and my co-counsel will be dealing with issue 3 and 4. If it satisfies your ladyships, if you want, I shall reiterate the facts of the case. Much obliged, your ladyships. Ladyships, however, I would like to mention that the SLP has already been granted, which our learned counsel prayed for that the SLP should be granted. It has already been granted by the Supreme Court. Your Lordships, further, I would like to move further with the first issue in our hand, which pertains to the FIR not liable to being quashed, and the same shall be dealt in a twofold manner. Firstly, that the offences fail to satisfy the extraordinary criteria for the judicial interference of section 482 of CRPC. Your Lordship, section 482 of the CRPC gives inherent power to the High Court to make or pass any such order, to give effect to any order of the CRPC, to prevent the abuse of process, and to secure the ends of justice. Your Ladyship, it is pertinent to note that criminal proceedings should not be scuttled at the very initial stage, because it is one of the rarest of the rare phenomenon happening, and it is not a rule, rather it is an exception of quashing of an FIR. Your Lordships, to support my argument, I would kindly request you to refer to the case of State of Haryana versus Bhajanlal, attached in page number 78 of the compendium. Your Lordships, this case gave us 7 parameters where quashing might be appropriate. First, the offences at the very prima facie level are not being disclosed. Second, there is no cognizable offence being disclosed. Third, even with the accompanying material, there is no offence being made out. Fourth, if the case involves non-cognizable offence, the investigation has been done without the magistrate's consent. Fourth, allegations are absurd or improbable. Fifth, if there exists a statutory bar, a prosecution cannot continue. And sixth, personal vengeance or ulterior motive. Your Lordships, our learned counsel accused us of having personal vengeance or ulterior motives because we approached the arbitration. Your Lordships, it is to be made clear that we did not approach the arbitration. It was the company who invoked the arbitration clause. We just went for the ARERA proceedings, that too when we did not have the forensic audit and an idea of that we were being deceptive from the very initiation, from the very launch of the project. Further, Your Lordships, we are alleging the company of criminal breach of trust, cheating, forgery, and Your Lordships, criminal conspiracy. However, my learned counsels does not even take up the matter of criminal conspiracy because maybe they also accept that there is a malicious intent behind their acts. Hence, they did not take up the matter of criminal conspiracy, Your Ladyships. Your Ladyships, if you may refer to point number 9 of the Moot proposition. There was a forensic audit released by during the CIRP proceedings, which identifies siphoning of the money of not only to the shell companies but also to the private family trust of Ms. Natasha Reddy, who is the director of the company. Your Lordships, these allegations at the very prima facie level prove to be of the nature of completing the ingredients of the offences we are alleging them of. The latter category of being alleged offences being absurd or improbable is totally baseless, Your Ladyships, because we are talking about the rights of 1,500 home buyers here. 1,500 home buyers together with CBI cannot have an absurd allegations, that too which from the very prima facie evidence presented before us are clear that they have siphoned off the money, they have breached their promises. Your Lordships, with this, I would like to conclude the first fold of this argument, and with your permission, if you are satisfied, I would like to move to the second fold of the argument, which is that that the mere existence of civil remedies do not bar us from approaching the court for penal deterrence of the company's acts. Your Lordships, it is respectfully submitted that the matter in our hands is not only a commercial exaggeration happening. If Your Lordships may refer to point number 9 of the proposition and point number 11 of the clarifications. Your Lordships, it is very clear. Your Ladyships, it is very clear that from the very beginning they had this malicious intention and they were diverting funds, that to 70%, that to 40% of it, to separate accounts. Your Ladyships, in the case of Paramjeet Batra versus State of Uttarakhand, which is attached in page number 57 of the compendium, it was held that that the cloak of criminality should not go unexamined. Even if there exists a civil remedy, it should not go unexamined if the matter is having even a hint of criminality in it. Your Ladyships, it is... may I continue, Your Ladyship? Much obliged. Your Ladyships, it is very clear that the company is having some criminal intent and that should be taken further. Why do they want? If they do not have any malicious intent, let the investigation be continued. Let the offense be established. Let the FIR be lodged. If they are not guilty, it will be proven that they are not guilty. Your Lordships.
The counsel for the petitioner has raised a question that there is nothing on record to show that the diversion was for purposes other than business. Can you draw our attention to a fact which shows that the diversion was for non-business purposes?
Indeed, Your Ladyships. Your Ladyships, if you may refer, just a second, Your Ladyships. Your Ladyships, if you may refer to clarification number 9.
9. Yes.
Your Ladyships, it explicitly states that crores was diverted to Natasha Lifestyle Venture owned by Miss Natasha Reddy's family trust. Your Ladyship, it is nowhere mentioned that this is in relation to the company.
No, it shows that there was a diversion to the trust and the company. The question they are raising is that where is the allegation that this money that was transferred for non-legitimate basis? Because it could happen that a related party transaction has happened. But where is the proof that there was no debt due and the money was transferred without any legitimate debt? That is the allegation which I believe your FIR is based on. So that means para 9 does not show us the absence of debt. So is this the only fact available on record?
No, Your Ladyships. There is also the fact that in clarification number 11, if I am not mistaken, that they promised us that they will be, during the launch, the very launch itself, they promised us that they will be using this money funded only and solely for the purpose for development of this project. However, they did not do it. At the very inception, they had this intention, Your Ladyships.
Okay.
Much obliged, Your Ladyships. Your Ladyships, in the case of Paramjeet Batra versus State of Uttarakhand, attached on page number 57, it said that the cloak of criminality should not go unexamined. Further, Your Ladyship, the mere existence of the arbitration clause in the agreement does not bar us from approaching the bench to have a criminal deterrence for the acts of the company. Your Ladyships, if you may refer to page number 71 of the compendium to the case of S.N. Vijayalakshmi versus State of Karnataka. Your Ladyships, it is
Ma'am, we don't have your compendium.
Your Ladyships, we did submit.
Okay, no problem. You continue.
Much obliged, Your Ladyships. Your Ladyships, in the case of S.N. Vijayalakshmi versus State of Karnataka, it was held that both civil and criminal proceedings can coexist as they serve two distinct and separate objectives. One, the civil remedies serve the objective of restitution and the criminal proceedings serve the objective of penal deterrence, Your Ladyships. It is therefore submitted that the independent yet parallel operations of civil and criminal laws ensure that while the victim seeks recovery, the directors are penalized for their actions. Hence, the FIR is not liable to be quashed at the very initial stage. Your Ladyships, if you are satisfied, I shall move with the second issue in hand. Much obliged. Your Ladyships, this issue pertains to whether the allegations at the very prima facie level constitute the offences or whether they are only a mere breach of contract. Your Ladyships, the same shall be dealt in a twofold manner. First, that the FIR identifies distinct offences with fraudulent intent since the inception, justifying the ongoing criminal proceedings. Your Lordships, I shall deal with the first deal. Your Lordships, you may refer to point number 17 of the clarifications. Skyline induced the home buyers with not only the promise of timely completion, Your Ladyships, but also of construction quality, which were only substandard, of using the funds only for this project, which was diverted not only to the sister concerns but also to the family trust, Your Ladyship, and also they ensured us that all the paperwork were in place, which were only achieved in mid-2016. Further, Your Lordships, the act of putting the celebrities' pictures without any disclaimer on it, even a small disclaimer at such an extensive level that they were using it just for the illustrative purposes, also acted as an act of inducement, your ladyship. It made us believe that the celebrities themselves endorsed the project. Your ladyships, this is the very essential of section 420 cheating, which is the inception and the fraudulent claims along with the conduct. Your ladyship, Skyline's actions are not civil in nature, since they are having fraudulent intent since the very inception, because in 2015 when they launched it, they made false representations. It is therefore submitted that these allegations at the very first hand prove that they are at the prima facie level sufficient for constituting cheating. If your lordships may refer to point number 12 of the clarifications. Your lordships, there have been clear evidence of fabrication of books of account, manipulation of progress report, audited balance sheets and documented board meetings with backdated fabricated signatures, your lordships. Your lordships, it is very clear, and it has been held in the case of Parminder Kaur versus State of UP, that backdated signatures are a sign of forgery. Further, your ladyships, our councils contended that it is not the responsibility of the directors to audit the balance sheets or to audit the reports. However, your ladyships, in the case of N. Narayanan versus adjudicating officer of SEBI, it was held that it is the responsibility of the directors, if they are making a decision, to check the files before they are signing it. Hence, their claim of forgery not being taken at the very first place stands unsettled, your ladyship. Forgery is taking place at the very prima facie level of not only one but many documents. Your ladyships, even in point number 10 of the clarifications, it is clear that Mr. Kapoor signed the forged completion certificates, and Ms. Natasha Reddy herself had her hands in the fabrication of books of accounts, your ladyships. Your ladyships, also if you may refer to point number 9 of the proposition, it is very clear that the funds made by the home buyer was purposefully entrusted for the development of this very project. Your ladyships, however, it has been contended that by the co-counsel that both are mutually exclusive and cannot go together. Lordships, we would like to invoke the doctrine of alternate charges under section 211 of the CRPC. Your ladyships, it specifically says when there is a haze in the matter that which section is being applicable. Since we were aware that we only had the option, we were aware that there is a delay, and later when the forensic audit came, we were aware that the diversions were also happening. So there is a haze in the offences. Hence, both the offences can be charged together, can be filed together. However, they will be convicted for either cheating or criminal breach of trust, your ladyships. Your ladyship.
Counsel, I'm also feeling a little hazy on the facts, so I want to ask you something. So first, when the issue went to CIRP, an audit report was placed. What facts were discovered in this audit report?
Your ladyships, if you may refer to point number 9 of the Moot proposition. Your ladyships, it was specifically stated that there was fabrication of books of accounts, diversion of project funds, creation of shell companies. And
so then you went to lodge an FIR. In the FIR, has any new additional fact been revealed in the investigation which led to the FIR in addition to this?
Indeed, your ladyships, after the preliminary inquiry done by the CBI, there were instances like the diversion to the family trust, the construction quality being substandard, the paperwork not being in place. These were the additions after.
Where is that clarification paragraph regarding additional information?
Your ladyship, however, additional information has not been stated. However, it has been stated in point number 9 that the forensic audit which was placed before the IPR shared with the CBI identifies the specific.
So that is only with respect to the audit report. My question is that post the audit report, what did the CBI find out in the investigation? Did they find out something in addition there too?
Your ladyships, however, I much obliged. In the Moot proposition, going by the Moot proposition, certain things were given in the forensic audit report. However, after the forensic audit report, a preliminary inquiry took place by the CBI, and after that, however not explicitly stated, but going with the facts. After that, the false representation part came into play, that they were not going with their promises, and there was no consent of the celebrities also for their endorsement. These came after that, after the preliminary inquiry.
So you're relying upon the no consent of celebrity as a part of a cheating. The no consent of celebrity you're reading into section 420.
Your Ladyship, that we are reading that as an act of inducement made to the home buyers.
For the purpose of section 420.
Indeed.
Okay. So that's the only new fact other than the audit report. Because I have a follow-up question. So I'm asking you again, other than the audit report which came on record from the CIRP and the factum of the personality rights being wrongly used, is there any additional fact that CBI learnt during the PE?
Indeed, Your Ladyship. Of the paperwork not being in place, of the construction quality being substandard.
Okay, where is the construction quality being substandard but discovered by CBI in the clarification?
Clarification number 17, however, not explicitly mentioned by the CBI, but it does not also mention that it is found out in the forensic audit reports. And Your Ladyships, if you may refer to clarification number 12. Are Your Ladyships with
So
me?
question number 12, we can presume that there may have been some additional facts, right?
Indeed, Your Ladyships.
Okay, all right.
Much obliged. If Your Ladyships are satisfied, I shall move ahead. Much obliged, Your Ladyships. Your Ladyships, we are also alleging them of conspiracy, Your Ladyships. Your Ladyships, first and the very foremost thing, they did not even contend that they are not having any criminal conspiracy. This means that they know that they are having a malicious intention and that they are protecting themselves in a garb of corporate debtor. Your Ladyships, if you may refer in arguendo that they have committed, though they are accepting it, but we are also arguing that they have committed criminal conspiracy. If you may refer to point number 9, point number 10 and point number 16 of the clarifications, Your Ladyships.
What about it?
May I proceed?
Yes.
Much obliged. Your Ladyships, it can be very clearly observed from these that the diversion of money was done in agreement of both Mr. Arjun as he approved the diversion, which was also in Ms. Natasha Reddy's family trust. And there are also found emails suggesting that they want to hide the diversion of funds, indicating that there is agreement. Further, Your Ladyships, if you may refer to page number 46 of the compendium to the case of Kehar Singh versus Delhi administration, it was held that the essence of the offence of criminal conspiracy lies in such agreement and the shared intention to achieve unlawful objective. Further, Your Ladyships, in the case of Swami Ratnam versus State of Madras presented in page number 85 of the compendium, it was held that the acts of cheating flowing through a common design is a strong and corroborative evidence of conspiracy. Thus, when such intent is accompanied by the conduct, it is to be named as criminal conspiracy, at least at the very prima facie level, hence making the FIR not liable to be quashed. Your Ladyships, if you are satisfied, I shall move with the second fold of this argument.
I just have one question because the petitioner has raised an issue that this is not a case where there was cheating at the inception. It may have happened during the performance of the transaction because they've not been able to deliver you the homes. How do you respond to that? Because the fact is today you do have half constructed flats on the site. It's not a case that money was taken and there's nothing on the site. You know, you do have permissions, you do have a half constructed building, but yes, it's not been finished. How do you respond to that submission of the petitioner?
Much obliged, Your Ladyships. Your Ladyships, responding to it, first and the foremost thing, clarification number 17 explicitly stated that during the launch of the very project, they made certain claims. And when they started the project, obviously it is since the inception. It is to be taken since the inception. They use substandard material. They made offenses, or they made claims like having all the paperwork in place which were only achieved. And Your Ladyships, it is to be noted that the agreement period is going on from 2015 to 2018, and the siphoning of money has started way back in 2016. Your Lordship, still they made the claims to the further buyers also that they were not siphoning any money and it was only used for the development of this project only.
So counsel, is it your case that in every contract where there will be delayed performance and substandard performance, it will always be a case of cheating? Are these two factors, if they coexist, is it sufficient to initiate a cheating complaint against every builder, or do you need something more?
Indeed, Your Lordships, we need more evidences, like we are also, Your Ladyships, much obliged. Your Ladyships, we are also contending that they have diverted our funds, our life loss saving of 1,500.
So that is the distinguishing factor.
Indeed, Your Ladyships.
So the fact that there is a delayed performance and there is substandard by itself are not sufficient to maintain the cheating complaint.
Your Ladyships, however, they made false representations which are to be taken as a standard.
Okay. False representations regarding the approvals.
Not only the approvals, of the quality of having the celebrities endorsing it.
Okay.
Much obliged, Your Ladyships. If I shall move with the second issue in hand. Much obliged. Your Ladyships, this issue is pertinent to note that this issue deals with the offences are not only civil in nature.
She wants to complete the submission.
If I may continue, Your Ladyships. Much obliged. Your Ladyships, it is respectfully submitted that a contract creates rights in personam and corresponding obligations enforceable by law, a breach of which very ordinarily attracts civil remedies. However, Your Ladyships, it is to be noted that if you may refer to the case of Anil Mahajan versus Bhor Industries attached in page number 11 of the compendium, it was held in that case that if the contractual obligation is done with a fraudulent intent since the very inception, it is to be taken as criminal in nature. Your Ladyships, in the present case, Skyline induced 1,500 home buyers, Your Ladyships, into the agreement in the garb of giving them their dream homes, which were only 30% completed in 5 years, Your Ladyships. 5 years is a long time. And they even defaulted on the repeated deadlines. It is not like they did not default any further. They defaulted on the repeated deadlines too. Hence, Your Ladyships, it is to be noted that they had fraudulent intention since the very inception, making it not only civil in nature but also criminal. Your Lordships, if you are satisfied, I shall call upon my co-counsel. Much obliged, Your Ladyships.
Hello. Greetings to the Honorable Bench. The Council will be dealing with issue number 3 and issue number 4 on behalf of the respondents. Your Ladyships, issue number 3 specifically deals with concerns the applicability of the moratorium period over natural persons of the corporate debtor. And issue number 4 deals with the violation of personality rights of both the celebrities, Mr. Vikram Suryavanshi and Ms. Priya Rajwat. If your Ladyships have no preliminary inquiries, the Council would like to begin. Much obliged. Your Ladyships, it is humbly submitted at the outset that the FIR was lodged against both Skyline, the corporate debtor, and its natural persons, being the directors, Mr. Arjun Kapoor and Ms. Natasha Reddy. However, it has only been challenged by the directors. Your Ladyships, it is humbly submitted that Section 14 of the Insolvency and Bankruptcy Code does not extend to natural persons of the corporate debtor, and the same will be substantiated in a twofold manner, where firstly it will be established that Section 14 only extends to the corporate debtor and cannot be used as an excuse for its natural persons to escape liability. And secondly, that both criminal prosecution and investigation are barred, are not barred, Your Ladyship, under section 14 of the AIBC. Beginning with the first fold of the argument, it is humbly submitted that it is in the very language of section 14 clause 1 clause A that it only extends to the corporate debtor, and the corporate debtor has been defined in section 3 clause 8 to mean corporate persons who owe any other person a debt. Your Ladyships, the definition of corporate persons does not include natural persons in section 3 clause 7. Further, in the case of Anjali Rathi versus Today Homes and Infrastructure, which is given on page number 14 of the compendium, para 15, Your Ladyships, page 14, para 15. It was held that the moratorium period only extends to the corporate debtor and it does not grant any kind of personal immunity to its natural persons. Here, Your Ladyship, I would like to highlight the landmark judgment of Anita Hadda versus Godfather Travels. Your Ladyship, while in that judgment, the Honorable Court held that both the company and the natural persons must be held liable. It also established an exception. Your Ladyships, in para number 51, which is given on page number 8 of the compendium, para 51, the very last line, Your Ladyship, the court established an exception and applied the legal maxim of lex non cogit ad impossibilia, which literally translates to however mandatory a provision may be, if its application and compliance has been made impossible, that is sufficient excuse for its non-compliance. Your Ladyship, the same line also talks of a legal impediment. Therefore, when there exists a legal impediment or a statutory bar that prevents prosecution against the corporate debtor, that will not prevent prosecution against the natural persons. And further, later on in 2021, in the judgment of P. Mohan Raj, this Honorable Court recognized section 14 as one such statutory bar that does not prevent prosecution against natural persons. Your Ladyships, here I would also like to make a reference to the case of Swiss Ribbons versus Union of India, in which the court talked about the very purpose of the moratorium period. Your Ladyship, it said that the purpose of the moratorium period is to prevent the assets of the corporate debtor and keep it a going concern. However, in the very next line, which is given on page number 89, Your Ladyships, page number 89, paragraph 28, the very last line which flows into the next page as well, it also bifurcated the interests of the corporate debtor with the natural persons. Therefore, it stated that the purpose of moratorium period is to preserve the assets of the corporate debtor and corporate debtor alone, and it does not concern the natural persons at all. Your Ladyships, therefore, the moratorium period is not meant to be used as a shield by the natural persons to permit abuse of the CIRP process. Section 14 must be read in a way that it preserves the interests of the corporate debtor, its investor, its creditors, and its investors, Your Ladyship, and should not allow the natural persons to escape liability or accountability for the actions and the offences committed prior to the CIRP proceedings. Your Ladyships, further, moving on to the second fold of the argument regarding...
Can I ask you one question?
Yes.
Would it make, you said, for the acts committed before the commencement of CIRP, would it make a difference if the acts are after the proceedings under IBC have been initiated?
Your Ladyships, as per the understanding of the Council, when CIRP process is declared under the moratorium under section 13 of the AIBC, it also, the management is suspended. Your Lordships, Ladyships, therefore the natural persons, they do not remain, such as the directors, they do not remain the management of the corporate debtor, and instead it is replaced by the interim resolution professional.
Therefore, they cannot be held liable for any act done after the IBC.
Your Lordship, they still can, because the moratorium period allows them to. It only bars prosecution against the corporate debtor. While the management has been changed, it has merely been suspended. It has not, even section 32A, which was referred to by the petitioners, section 32A applies after the moratorium period has ended, and it separates the liability of both the corporate debtor and the natural persons. It allows the natural persons to still be prosecuted even after the moratorium period. And what we are submitting here is that the proceedings against them should also continue during the moratorium period, because their interests are different from that of the corporate debtor and the assets of the corporate debtor, Your Ladyships. If Your Ladyships are satisfied, the Council would like to continue. Much obliged. Your Ladyships, further it has been recognized in the case of Varsana Ispat versus Deputy Director of Directorate that criminal proceedings are not barred. Not only is Section 14 inapplicable towards criminal proceedings, it is also inapplicable towards any actions that were taken in pursuance of the criminal proceedings. Therefore, Your Ladyships, the preliminary inquiry which was done by the CBI after the criminal complaint was filed, or any kind of investigation that will take place after the lodging of the FIR, both are also not barred by the moratorium period, Your Ladyships. If Your Ladyships are satisfied, the Council would like to move on to the fourth issue. Much obliged. Your Ladyships, it is humbly submitted that the unauthorized commercial use of the identity, likeness and persona of the celebrities for advertisement purposes amounts not only to a violation of their personality rights, specifically right to publicity and right to privacy, but also amounts to a tort of misappropriation. The same will be substantiated in a threefold manner, where firstly it will be established that it violates their personality rights, being right to publicity and right to privacy. Secondly, that it amounts to a tort of misappropriation. And finally, that that for this they should be granted a permanent injunction and a claim for damages which should lie in front of the IRP as a form of a claim, Your Ladyship. Your Ladyship, you asked a question regarding how the celebrities are party to this matter. Your Ladyship, as per paragraph 14 of the Moot proposition, the petitioners themselves made them a party, seeing that they had an interest in the assets of the corporate debtor, being Skyline. And Your Ladyship, it is humbly highlighted that, as also highlighted by my co-counsel, that the offence of cheating that we are establishing here is through the inducement that happened by the misuse of celebrities' persona and likeness, Your Ladyship. Your Ladyship, their identity was not only misappropriated for commercial use, it was also to commit cheating against the home buyers, Your Ladyship, which is in direct relation to the FIR which has been filed and the offences that have been mentioned in the FIR. Therefore, the celebrities are here today contending the matter of their personality rights violation, not only by the use, but also by the offence that was committed using their identity. If that satisfies Your Ladyship, the Council would like to continue.
I fail to understand what is the relevance of these personalities in these criminal proceedings at all. And if are you representing the prosecution or the home buyers or the personality rights right now?
All three. We are representing all the home buyers, the celebrities and CBI as well.
I fail to understand your presence in these proceedings.
They are victims.
Your Ladyships, what we are trying to argue that first of all the petitioners made them a party in the matter.
Petitioners have said that they did not request for it. They have clarified that it was done at either your instance or they don't know, maybe the court's instance.
Your Ladyships, it is given in the very line that they were made parties to this matter.
Yeah,
and
but there is some ambiguity. The made parties could be either by the order of the court, or made parties could be either at the request of the respondent or the petitioner.
Your Ladyships, as the petitioners are interpreting it to be made by the court, then we will also assume it to be as made by the court itself, and therefore we will try to contend the same.
But I can't see any legal justification for the personalities' presence in these proceedings.
Your Ladyships, the celebrities their fundamental rights are also being violated, and the reason why they are here and the FIR, they are a party to the matter, is because the offences that are named and that the FIR has been lodged with, those very offences were committed using those celebrities' identities, Your Ladyship.
But you yourself identified that you have a claim for damages and injunction which you are pursuing in a civil court, and if you succeed in any decree of damages, you will enforce it against the company. But nothing other than that.
Your Ladyships, however, only merely an interim injunction has been passed by the civil court, and the matter is at a standstill because of the moratorium period, because it bars the civil proceedings. And Your Ladyships, here we would like to establish that the civil proceedings, it is only going on against the corporate debtor. Your Ladyships, in the after the audit report came out,
is it still going on?
It says the interim. It says that the interim injunction has been given. It does not say whether it has been reached its final.
But now that you have read section 14, do you think it can go on?
Your Ladyship, it has been barred. It has been barred.
Not barred, stayed.
Yes, it has been halted for now because of the moratorium period against the corporate debtor. Your Ladyships, however, what we are contending is, it was not just the involvement of the corporate debtor by using their identity. Your Ladyships, given in clarification number 10, it is explicitly stated that Ms. Natasha Reddy, she herself authorized the unauthorized use of the likeness of the celebrities. Therefore, she herself had a hand in authorizing the use. Therefore, such proceedings against a natural person should still go on, Your Ladyship, because they themselves authorized the use. If Your Ladyships are satisfied, the consent. Much obliged. Your Ladyships, starting with the first fold of the argument, it is humbly submitted that the right to publicity refers to the right to control the commercial use of one's identity. Your Ladyships, as highlighted in the case of ICC Development Limited versus RV Enterprises, which is given on page number 40, para 14 of the judgment, Your Ladyships, it was held that this right to publicity vests with the individual and he alone has the right to profit from it. Your Ladyship, therefore, when it comes to a celebrity's personality and use of the same for advertisement purposes, celebrities themselves must have the right to choose where, when and in what manner their identity is to be used. This, Ladyship, the Delhi High Court established in the case of Titan Industries Limited versus Ram Kumar Jewellers a two-pronged test to check when right to publicity is being violated of a celebrity or of any individual. Your Ladyship, the first prong of the test is when the validity of the identity has been established. That is when the celebrities have an enforceable right in their own identity. And secondly, that the celebrities are identifiable by the commercial unauthorized use. Your Ladyships, if you would kindly refer to para number 2 of the Moot proposition, which refers to Mr. Vikram Suryavanshi as a popular film actor and Miss Priya Rajwat as a celebrated cricketer. Your Ladyships, both through years of professional exertion, skill and cultivation of public trust, have developed a marketable reputation. Therefore, they both have an enforceable right in their own identity.
All right. My one question is that their personality rights are being violated. That gives rise to a civil liability. What offense has been committed in these circumstances by, what is a criminal offense vis-a-vis these two personalities that has been prima facie made up?
Your Ladyship, while we recognize that these are civil disputes largely, we also recognize that because of these civil disputes, there was a criminal offense that happened against the home buyers.
What offense?
Your Ladyship, cheating under 420. Home buyers were cheated. They were induced into this project, Celestial Heights, through the advertisements which falsely used and by unauthorized way used the celebrity's identity to induce such home buyers into the project, Your Ladyship. Therefore, the very offense against the home buyers using the celebrity's identity is a criminal offense, Your Ladyship. The personality
Can you turn to issue number 4? You're addressing us on issue number 4, right?
Yes, Your Ladyship.
Can you just slowly read it out? Can
Yes,
you just patiently read it out? Just read it out.
Whether the unauthorized use of a celebrity's likeness and persona for commercial promotion of a real estate project without consent constitutes a violation of their personality rights, right to publicity or privacy, and amounts to the tort of misappropriation.
Pause.
Yes.
So the answer is yes.
Yes.
Now we'll read, that's one part of the question. Now the second part of the question.
Yes.
Yes.
If so, what is the appropriate remedy and hierarchy of adjudication for such a claim, particularly when the corporate entity has
So
understood?
the only question you have to answer is that what is the remedy and hierarchy of adjudication? Actually, the question does not even contemplate any criminal proceedings at that instance. But now you have to answer this question for us. So what is the remedy and hierarchy of adjudication of such a claim?
Your Ladyships, first of all, we would like to argue, this was the last fold of my argument, however, I will deal with this right now. Your Ladyships, what we are arguing is that we understand that the moratorium period is underway, therefore no new civil proceedings can be instituted or continued against the corporate debtor specifically. However, already established that such proceedings cannot be continued against natural persons, such as Natasha Reddy, Your Ladyship, because she authorized the use. Your Ladyship, secondly, we claim that if the damages may be awarded to the celebrities in the form of a claim before the interim resolution professional, Your Ladyship. Your Ladyship, interim resolution professional under the CIRP guidelines of CIRP regulations of 2016 it has been allowed that they can not only admit a claim, they can also check the validity of the claim using the necessary evidence, and then later further on they can also determine the amount of such a claim. Therefore, we are interpreting the section to be that they should be the IRP, the interim resolution professional, should be allowed to evaluate such a claim and therefore award damages if the court allows.
That's the remedy.
Yes, Your Ladyship.
One question is, can the IRP adjudicate and decide what are the damages to be paid?
No, Your Ladyships. However, that is why we are in front of this court, that if the court allows the IRP to do so, if the IRP be allowed under the powers that they have,
No, but where there are claims, they can verify whether somebody is entitled or not. But they can't decide, adjudicate on damages to be decided from the scratch on disputed facts. They can't take evidence. See, IRP can only decide the claims that are filed, but not adjudicate on damages.
Much obliged, Your Ladyship. Your Ladyships, what we are interpreting here is the definition of a claim under Section 6 of the IBC, Section 6, Clause A. Your Ladyship, a claim is defined as a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. Your Ladyships, we are referring to a disputed claim here. And Your Ladyship, such claims can be submitted to the IRP, and also as very correctly highlighted by the petitioners that they are 100% guaranteed to receive such a claim.
What would be the damage or the claim of the two personalities? If they say we are entitled to 2 crores, is the IRP going to give them?
Your Ladyships, that can be calculated on the basis of the number of how much advertisements were used, whether they were continuous throughout the years, what was the extent of the advertisement, Your Ladyship, the ways in which the advertisement happened, and how many home buyers were induced through the same, how much profits did Skyline and its directors earn through those advertisements in the first place. All that can be taken into account to determine the amount of those damages. If that satisfies your court. Your Ladyships, if I may continue back to my personality rights argument, if that satisfies the third fold. Much obliged. Your Ladyships, as already established, that their personality, their right to publicity is being violated and infringed. Because first of all, the first prong of the test, which was an enforceable right in one's own identity, that is being satisfied. And the second is the identifiability of the celebrities from that very advertisement. Your Ladyships, in clarification number 1 itself, it is stated that the home buyers during investigation came forward and said that they were induced through those very advertisements, and that is why they invested in the project, Your Ladyship, and they thought that both the celebrities had personally endorsed the project. Your Ladyships, further, in the case of R. Rajgopal versus State of Tamil Nadu, a landmark judgment, the court held that the use of a celebrity's likeness without their consent for advertising purposes amounts to a violation of right to privacy. And Your Ladyships, this judgment laid the foundation of right to privacy being included in Article 21 of the Constitution. Therefore, Your Ladyship, it also amounts to a violation of the fundamental rights as well. Your Ladyships, moving on to the second fold of the argument regarding tort of misappropriation. Your Ladyships, in the case of Ellora Industries versus Banarasi Das, which is given on page number 30 of the compendium, para 23. Your Ladyship, tort of misappropriation, the tort has been defined, and the misappropriation, it refers to an extension of passing off, and when the identity, when the business or professional reputation of a person is wrongfully misappropriated, wrongfully appropriated with the purpose to confuse or deceive the customers, Your Ladyship. That is what tort of misappropriation is. Your Ladyships, in the present case, the persona of both the celebrities was used without any authority and with a malified intent to establish their association with the project, thereby trying to deceive the customers into investing into the project, Your Ladyship, therefore amounting to a tort of misappropriation. Your Ladyships, in the present case, the project, they did not have any disclaimer as well at all, stating that they had no use. Your Ladyships, they not only used their pictures, they also altered them to in different hoardings to set in the backdrops of the buildings, and to create a direct association between the celebrities and the project, therefore directly inducing the customers to invest into the project, Your Ladyship. Your Ladyship, therefore, it is humbly submitted that the unauthorized use of a personality, of a celebrity's identity amounts to a violation of their personality rights, specifically right to publicity and right to privacy, and it also amounts to a tort of misappropriation, for which, as already established, that the court may grant the IRP the permission to give the claim for damages.
You are again and again saying it's a tort of misappropriation, the right to privacy infringement. All these aspects are civil. They don't become criminal. So is there any criminal crime committed vis-a-vis these two personalities? Maybe you were saying home buyers have been cheated, defrauded. What is a criminal offense committed vis-a-vis these two?
Your Ladyships, while we are not contending any criminal use of their identity, we are still contending that it was used misappropriated to deceive the customers.
And are they here in what capacity? Are the witness or the victims?
Your Ladyships, they have been made a necessary party as the contesting respondents. Therefore,
are they victims or witnesses in this offense?
Your Ladyships, a victim themselves, because their identity was used to deceive the home
But
buyers.
there's no offense, no criminal offense against them. It's all civil liability. So obviously they have to be witnesses and they are not victims.
Much obliged.
That distinction you must remember.
Much
right?
obliged, Ladyships. Much obliged. If your Ladyships are satisfied, the council would like to move on to the prayer. Much obliged. Wherefore, in the light of the issues raised, arguments advanced and authorities cited, the respondents most humbly and respectfully pray this honorable court and request to firstly declare the FIR number RC05-2021 should not be quashed. Secondly, declare that the FIR discloses prima facie ingredients of offences of cheating under section 420, criminal breach of trust under section 406 and forgery under section 467 of the Arunashtan Penal Code. Thirdly, declare that the moratorium period under section 14 of the Arunashtan Insolvency and Bankruptcy Code does not operate as a bar against the investigation and prosecution of natural persons of the corporate debtor for offences committed prior to the CIRP. And lastly, declare that the unauthorized use of a celebrity's likeness and persona for commercial promotion of a real estate project without consent constitutes a violation of their personality rights and amounts to a tort of misappropriation, and or pass any other relief which this honorable court may be pleased to grant in interest of justice, equity and good conscience, and for this act of kindness the respondent shall be duty bound forever. Great. Thank you, Your Ladyships. It was an honor pleading.
Before you leave, one last question.
Much obliged.
Can there be charges under 420 and 406 framed simultaneously?
Your Ladyships, as stated by my co-counsel itself, a provision in the CRPC allows the very court to, at at least the prima facie level, when an FIR is being lodged, it allows them to use alternative charges, Your Ladyship. Therefore, when the investigation is not complete, it cannot be made whether the intention was at the very beginning or it was developed later on, while we are contending that it was at the very beginning. Still, after we are contending that the FIR should go on and the investigation will tell that which charge they should be tried for. Much obliged, Your Ladyship. It was an honor pleading before you.
Ask them to go out of the room, then we'll quickly mark and give the marks. Courtmaster, you can ask the teams to leave. We'll just mark and give you the marks. Yeah, you can ask the teams to leave right now. You want to say something? Okay. All right. Okay.
Sir, Rich over here.
I won't waste much of time's court. I'll just bring few rebuttals we have regarding procedural grounds. Your Ladyship, IBC is a self-contained code created by the Parliament in 2016. Section 66 of IBC clearly says, if the IRP finds any allegation of fraud or misconduct, the IRP should go to the adjudicating authority, who will refer, if there are elements of crime, to a special court. That is, the IRP should go to NCLT, which will refer to the special court. This process was completely circumvented, and they directly the IRP did not, even the IRP did not approach the CBI. The IRP shared their findings with the home buyers, who went and filed the FIR with the CBI. You can clearly see how the process has been abused, where the IRP did not follow the statutory mechanism it was provided to them, and the IRP shared their findings to the home buyers, who went and filed the FIR with the CBI. That is our first contention with the procedure here. The second fact I would like to bring up here, Your Ladyship, is about how our learned friends on the other side mentioned that the promise was made to home buyers that their 70% would be kept in escrow accounts. That is not true. There is nothing in the facts which reveal that the promise was made to the home buyers. That is the RERA regulation, which, even if we take at the face value, was violated. Nothing in the facts. Nothing in the facts which show that the promise was made explicitly to the home buyers, and that promise was broken. Hence, there was an intention. In all of their submissions, they do not prove that the petitioners here had the intention. They do not completely explain to the court, as I mentioned during my submission, entrustment happened, but how the entrusted money was used. All they end with is diversion of funds, not that it was used for the purposes it was never intended to. These are one last submission is that there is also one procedural misconduct here. When the Delhi Special Police Act clearly says that when CBI investigates a matter or a criminal matter, it has to take the consent of the state. Nothing in the facts reveals that the CBI took the consent of the case, consent of the state involved here. Also, the question about why they did not approach the state police and directly went to the CBI police. None of this is answered by this, and these are all come under the broad aspects of abusive process. This court has taken into cognizance and has washed the FIR. These are my submissions. Thank you. My co-counsel will just make one submission regarding the personality rights, the rebuttal to that personality rights. Thank you.
Yes, please.
As your ladyship so rightfully held that the statutory law and the facts are against us in issue 3, we would like to concede issue 3 and move on directly to issue 4. Your ladyship, the issues with issue 4 is that the photographs were procured from an event management company, which is provided in clarification 2. Your ladyship, this should concern the celebrities, rightfully so, but their dispute should be with the event management company for giving us the photos without the consent of the celebrities, rather than with us utilizing these photos. We weren't aware of the fact that these celebrities had not consented to the fact, because it is completely private dealings with the event management company.
Clarification number 9 says that Ms. Natasha was aware about the unauthorized use.
No, Your Ladyship, it just says that she authorized the unauthorized use.
Yes, she did authorize, yeah.
One last submission, Your Ladyship, is that celebrities cannot be a part of the IRP process as well. Mainly because the IRP process, although they do allow for the admitting of claims, and it is a duty of the IRP to admit for the claims, they have to follow a structure that ensures that the secured and unsecured liquidators are first provided their claims. Which in this instance, Your Ladyship, if you were to look at the facts and believe that the company funds were diverted and so on and so forth, the company is currently under severe financial stress, which means in this essence, the only reasonable method for them to approach would be through the district court, and the district court, the only damages that can be paid in this endorsement would be through reference to the case law Irvi versus Talksport Limited, which has been the standard throughout the world, Your Ladyship, where they essentially say that the only damages that can be claimed should be in notional endorsement fees for what they would have charged for a small, reasonable amount. That's all, Your Ladyship. Thank you so much.
आप भर लो, हमें just We'll go on with that.
You can proceed.
First of all, it is argued that the council said that we should have approached the local police authority instead of the CBI. Your Ladyship, no provision bars us to directly approach the CBI, and we did not directly make an FIR. We filed a criminal complaint and the CBI conducted a preliminary inquiry, only then filed an FIR, Your Ladyships. Therefore, it was well within our rights, and this is not a matter of just 1 or 2 home buyers, Your Ladyships. It is 1,500 home buyers. Not all of them could have gone and filed individual complaints with the local police, Your Ladyships. Therefore, the CBI was the more appropriate authority to refer to in this matter, and that's what the home buyers did.
Are you aware of the statutory provision that entitles a citizen to directly approach CBI?
Your Ladyships, I have limited knowledge on the same. However, the council knows that you can either write a mail or a letter to the CBI filing a criminal complaint, and therefore they can, it's on the CBI to decide whether to take the matter or not.
In the fact, since this was not a ground in the SLP, we will not take it into consideration, but we are presuming there must have been appropriate permission granted to CBI, because I think his contention is correct, but he's taken this ground outside the brief, so we are not going to entertain this ground.
Much obliged, Your Ladyships. Your Ladyships, further it is also humbly submitted that they said that they established that the celebrities cannot go in front of the IRP and they can, as they are not creditors, Your Ladyships. However, has already established that they can file a claim, and it is humbly argued that they should fall within the definition of an operational creditor, and not a financial creditor but an operational creditor. And Your Ladyships, as per the waterfall mechanism given in the IBC itself, the operational creditor, while not at the first instance, can still get the claim at the very last, Your Ladyships. And that is fine by the celebrities. As long as they're getting their damages, it's fine if they're getting it at the very last as well.
I haven't seen the provision, but I have my serious doubt that a tortious claim would form part of an operational creditor. I have my serious doubts, but again, I haven't examined the provision, so it seems untenable.
Much obliged, Your Ladyships. The council like rest. Much obliged.
RNM 09, Speaker 1 was given 20 minutes and has taken 21.5 minutes, while Speaker 2 was given 19 minutes and has taken 22 minutes. RNM 21, Speaker 1 was given 21 minutes and has taken 23 minutes, while Speaker 2 was given 21 minutes and has taken 24 minutes. Thank you.
Courtmaster, should we close the proceedings now?
Yes, ma'am.
Okay.
See, I think we'll in this, and I would say the benefit has gone to all the participants who are here, who have also learned this great art of mooting. It's a great learning to be able to debate or argue, and I think all of you deserve a compliment that despite we both being a little tough, you all could stand and answer the questions. Some of them were intended to be a little difficult, but the way you all answered, I think that was good advocacy, I would say. Secondly, to all who are present here, I would say that what is important in a competition like this is not who wins or who loses. The most important thing is participation, because by that you all have learned a lot. All of you are, I think, the winners who are here, and all of you have done fantastically well. But see, you may win even in the courts, not always because you had a good case, but maybe you were better prepared and the other party was a little less prepared, or maybe you had a better case in your favor than the other party. So always take it as a learning and don't get disheartened by whatever be the outcome. I think the biggest compliment to any advocate is that you argued it well. And I would say all of you argued very well. Congratulations.
I think I can't add to what the senior judges already said. I think you both were very, very commendable. I think your clients were very, very lucky to have both of you represent them. But yes, it will always be the case of the complainant, and I think they have succeeded, to prove that this matter has to go on to trial. And be that as it may, it has really been a pleasure to hear all of you. You all have been so well prepared. And all the best. I hope it's a great learning experience for all of you. Thank you.
All right. With this, we adjourn the court and please await the final judgment. It will come soon. Right? Thank you. Thank you.
सबको क्लियर अप करना है
Hello. Four volunteers, please come to the bench, and we need your help.
Guys, we need 4 volunteers here, please.
Excuse me, guys, we request a few volunteers to come ahead.
Hello, hello. Hello.
आलोक अनुपम श्रेष्ठ सुंदर दिल्ली विश्वविद्यालय विहंगम जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम सकल वसुधा निज कुटुंब की भा
Hello. Hello.
I request everyone to be seated. I request again everyone to get seated.
I request everyone to please take their seats and settle down.
Hello. I request everyone to please maintain silence.
I request everyone to please settle down and maintain the silence of the room.
Hello. Hello, hello.
Students. ये चल रहा है? Hello, hello. Hello. Please be seated. Hello.
Hello. Hello. Hello. Mic check. Hello. Mic check 1, 2, 3.
Hello, hello. Kindly take your seats and please be seated.
Hello, check, hello.
Yeah, good evening to all and one present here. Respected Chief Guest, Honorable Justice, Mr. Justice K.V. Vishwanatham, Judge Supreme Court of India, Guest of Honor, Honorable Mr. Justice Devendra Kumar Upadhyay, Honorable Dean and Head, Professor Dr. Anju Wali Tikku Ma'am, Faculty of Law, Professor in Charge, Professor Dr. Manju Arora Rellan Ma'am of Law Center 1, Senior Advocate Shri Puneet Mittal, Chairperson of R.N. Mittal Memorial Moot Trust. Judges of the final rounds, Honorable Ms. Justice Manmeet Preetham Singh Arora and Honorable Ms. Justice Neena Bansal Krishna. And judges of the Prelims 1, Prelims 2, Octa, semi-final rounds, and the distinguished faculty members, honored guests present here, dear participants, dear students, again a very good evening to all of you. Today, as we gather here for the valedictory ceremony of our first edition of Law Center 1, R.N. Mittal National Moot Court Competition 2026. I, Dr. Apeksha, the convener of Moot Court Society Law Center 1, stand before you with the deep sense of gratitude. What began as an idea now has transformed into a successful academic endeavor today in the form of first edition of Law Center 1 R.N. Mittal National Moot Court Competition. And this first edition really holds a special place at the Moot Court Society Law Center 1 because from past 3 days, we have witnessed a lot of hard work from the participants, a lot of dedication, and a zeal for persuasive advocacy to persuade the judges. And moreover, we have never witnessed in the 52 years of Law Center 1 such a grand moot court competition that we have to transform the new building of this Law Center 1, Umang Bhiwan, into a simulated courtrooms. All the classes are booked as courtrooms for the last 3 days. For approx 58 teams, 60 registered, 2 backed out, for approx 58 teams from across the country, along with approx 150 judges again across from the country. Many eminent lawyers, legal personalities were here to judge the participants. And everyone has appreciated the participants as well, their legal reasoning, etc. So, again, I express my gratitude towards all the members of R.N. Mittal Moot Court, R.N. Mittal Memorial Trust, including Pratima ji, RP ji, Arvind ji, etc. I may not be knowing all the names, but they were also very helpful. And the Treasurer, Alumni Association at Faculty of Law, Mr. Jitendra Singh Mittal, who really acted as a bridge between the two associations for them and for us. And the distinguished and esteemed faculty members, the executive members of our Moot Court Society, the mentor board. I'm not recalling all the names, the members of names of the executive members and mentor board like Priyanshu, Ankur, Anjali, Nehal, Kajal, etc., etc. Please, I can't recall everyone's name here. So a big thanks to all the volunteers who participated from the last 3 days and worked day and night to make this event successful. So thanks a lot. And with this note, I again welcome you all for this valedictory ceremony of the first edition of RN Mittal National Moot Court Competition. And now I would like to invite our judges for the lighting of lamps.
Now, we would request everyone to kindly stand for the Kulgeet of University of Delhi.
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम
श्रेष्ठ सुंदर दिव्य दिल्ली विश्वविद्यालय विहंगम
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम सकल वसुधा निज कुटुंब की भावना संस्कृति सनातन आधुनिक शिक्षा पुरातन ज्ञान धाराओं का संगम
देश की स्वाधीनता हित भूमि का शतकोटि वंदन
निष्ठा धृति सत्यम के मंगल दिव्य भावों का समागम
जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम
भव्य महा महाविद्यालयों के परिसरों से चिर सुशोभित श्रेष्ठ गुरुजन कर रहे नित्य छात्र और छात्राएं दीक्षित
सदचरित्राचार पावन साधना संकल्प संयम
नवल वैश्विक चेतना नव क्रांति संस्कारों का उद्गम जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम
श्रेष्ठ सुंदर दिव्य दिल्ली विश्वविद्यालय विहंगम
जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम
ज्ञान का आलोक अनुपम
ज्ञान का आलोक अनुपम
ज्ञान का आलोक अनुपम
Now, before we proceed, we wish to pause and acknowledge the privilege it is to have such an eminent dais with us today. In recognition of the distinguished contributions and as a mark of our highest regard, we would now like to formally felicitate our honored dignitaries.
We are deeply privileged to have the gracious presence of Chief Guest, Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India. May I request Professor Dr. Anju Wali Tikku ma'am along with Mrs. Pratima Gupta ma'am to felicitate sir with a token of our gratitude. Thank you, sir, for gracing us with your presence.
It is our distinct honor to welcome our guest of honor, Honorable Mr. Justice Devendra Kumar Upadhyay, Chief Justice, High Court of Delhi. As a token of our gratitude, may I request Professor Dr. Manju Arora Rellan ma'am, along with Mr. Arvind Kumar Gupta sir, to kindly present a token of our regard. We are truly honored to have you here, sir. We would like to take this opportunity to highlight that the artwork presented here has been meticulously crafted by the remarkably talented, specially abled children of the Parivartan Foundation.
It is our privilege to welcome Shri Puneet Mittal, Senior Advocate and Chairman of R.N. Mittal Memorial Trust. As a gesture of our appreciation, may I request Dr. Apeksha Kumari ma'am to kindly present a token of our appreciation. Thank you, ma'am, for the felicitation.
We now request Mrs. Bhadra Mittal ma'am to graciously step forward to felicitate Professor Dr. Anju Wali Tikku, Head and Dean,
Faculty of Law, University of Delhi, as a mark of our deepest respect and appreciation for her invaluable guidance and leadership. It is an honor to have you here, ma'am.
Next, we acknowledge the invaluable guidance of Professor in Charge, Law Center 1, Professor Dr. Manju Arora Rillan ma'am. I request Advocate Yogansh Mittal to kindly present a token of our respect. Thank you, sir, for the felicitation.
It is a privilege to welcome patron of the R.N. Mittal Memorial Trust, Shri K.C. Mittal, sir. May I request Dr. Mercy K. Khote, ma'am, to felicitate sir with a token of her gratitude. Thank you, ma'am, for the felicitation.
We are pleased to welcome Shri Arvind Kumar Gupta, Advocate, Supreme Court of India, and founder of R.N. Mittal Memorial Trust, whose presence today is a source of great encouragement for all of us. I request Basuki Nath Dubey, sir, Assistant Professor, Law Center 1, to kindly present a token of our appreciation. Thank you, sir, for the felicitation.
We also extend a very warm welcome to Mrs. Pratima Gupta, ma'am, former judicial member, Central Administrative Tribunal, and founder of R.N. Mittal Memorial Trust, for her presence and support in organizing this program. I request Dr. Akshay Kumar, Assistant Professor at Law Center 1, to kindly present a token of appreciation. Thank you, sir, for the felicitation.
To bring together the reflections of the Moot Court competition and set a fitting tone for the evening, I respectfully invite Professor in Charge, Professor Dr. Manju Arora Rillan ma'am, to address the assembly.
Honorable Mr. Justice K.V. Vishwanathan, Judge Supreme Court of India. Sir, I welcome you. Honorable Justice Devendra Upadhyay, Chief Justice, Delhi High Court. Sir, I welcome you. Dean, Faculty of Law, Professor Anju Tikku, I welcome you, ma'am. Shri Puneet Mittal, Senior Advocate and Chairman of R.N. Mittal Memorial Trust. Sir, I welcome you. And the other judges of all the rounds of this moot court competition who are present here, and they have given their memorable contribution to make this event to be a successful event. And very important is, my dear participants and students, I, being professor in charge, take this pride to welcome you to this valedictory ceremony of moot court competition. LC1 has always been committed to fostering such academic activities that promote advocacy, critical thinking, practical legal approach. I am also thankful to members of R.N. Mittal Memorial Trust, who collaborated us in making this event to be a grand event. I'm also thankful to Moot Court Society, LC1, for putting their valuable efforts in making this event to be a grand success. Hope all the team participants have enjoyed this competition. Around, as already stated by our convener, Moot Court convener, Apeksha Kumari, that around 150 well-versed judges and around 58 teams participated in this event. This showed the fierce competition which was present in this Moot Court competition. And very important, this is an address to my galaxy of budding lawyers, that this was a journey which was filled with learning, growth, challenges, and memorable achievements. This is a celebration of perseverance and dedication. Each one of us will carry forward not only the knowledge we gain, but values, friendships, and experiences that shape your future in the coming time. And this is a time to celebrate these moments when all of us has done our part of job to make this event to be a grand success, and being our first national moot court competition. We tried our best to prove ourselves to be best. And I think we have proved it to a great extent. And my heartfelt thanks to all volunteers who have worked day and night to make this event to be a gala event. And with this, I once again thank everyone present here for their valuable contribution, and I look forward to witnessing these kinds of competition to grow even with greater heights in the years to come. Thank you once again.
We extend our sincere gratitude to ma'am for her insightful and encouraging remarks.
It is now my privilege to invite Professor Dr. Anju Valiteku, Head and Dean, Faculty of Law, to address the gathering.
Namaskar. I am amazed that amongst a house full of youthful energy, there is no response. तो जो मेरे साथ के हैं वो सब बहुत अच्छी तरह से जानते हैं कि मैं यहाँ से आगे बढ़ ही नहीं सकती जब तक आपका जवाब नहीं आता. So namaskar, good evening to each one of you. That makes it meaningful and sensible that we now are talking to each other. Thank you very much for responding to that call. First and foremost, सर आपका बहुत बहुत धन्यवाद, बहुत बहुत धन्यवाद श्री विश्वनाथन जी का. करीब 4 महीने पहले मेरी सर से मुलाकात हुई थी एक मीटिंग में एनजेए के सिलसिले में. वी हैड अ मीटिंग wherein I offered him, rather I requested him that I would be inviting you for an orientation program, but as luck would have it, I couldn't make it, and somehow or the other, one or the other engagement, administrative compulsions, responsibilities, calendars did not make it possible. But I am really thankful that you are here, and now I promise you that before I demit my office, you would certainly be here again, interacting with students, because the very short span I happened to see him addressing certain questions, I believe here is a person who understands the nuances of everyday life and how do we move forward. So as budding lawyers, we need to learn from our honorable guests, and it is indeed a moment of pride and pleasure. और आज पहली बार कह रही हूँ हमारे दोनों invited guests, ऐसा मौका है कि फैकल्टी ऑफ लॉ से पढ़ के नहीं निकले हैं. अदरवाइज हम हमेशा जिनकी को भी बुलाए हैं, जितने भी बुलंदी से बुलाए हैं, वो कहीं ना कहीं हमारी फैकल्टी से कुछ ना कुछ सरोकार रखते हैं, पढ़ के गए हैं किसी ना किसी तरीके से, चाहे वो उन्होंने LLB किया हो, चाहे मास्टर्स किया हो, चाहे PhD किया हो. बट आई एम रियली थैंकफुल दैट perhaps this turns out to be an intersection of meeting different ideas from different zones. And then इस मौके पे सर आपसे मैं निवेदन करूंगी, जो आपने सवाल मुझे दिया था ना, वो मैं वापस आपको दे रही हूँ, that how do we move forward with reference to opportunities to be created for students, because Justice Upadhyay told me, rather asked me, now I have a question to you. He asked me, because I asked him two simple personal questions about kahan se padha kya. Unhone bola if I might ask you. And then he said that you have got huge number of students. So what are your plans with reference to their placement? Honestly, I am dumbstruck even at this point of time. I do not have those opportunities. And we can only look forward to our alumni like Puneet, Pratima, and others. हमारे मित्तल जी, हमारे लूथरा जी. So these are the people who think about the institution and come back to us, and this is what we can possibly think. And this is what we have been visualizing, or it is on one-on-one basis. We recommend people across to our known circles. But there's nothing specifically institutionalized in the sense of having a dedicated placement which goes on and on and on continuously around the year. And that's where I informed you, sir, that we have floated our alumni association, and very soon we would be approaching you. Though you are not our alumni, but for sure. Alumni association can put requests across to different segments and people from different fields, different regions, to connect us to their acquaintances, their friends, to bring newer opportunities and openings for our young students, because I really feel privileged standing before you to inform, because there are many participating students who are not from Faculty of Law, Delhi University. We happen to have at any given point of time, as far as undergraduate course is concerned, 9,000 plus students. So even if some drop out, it's more or less 9,200, 300 that every year that much number of students, 3,000 plus passes out. So we need to create opportunities for them. And opportunities does not mean that, yes, to begin with, they get into any stream and then they feel stagnated. So with that opening expectation, that opening remark, now my responsibility as Head and Dean of the Faculty of Law, first and foremost, I am a teacher and a professor from Law Center 1, though I graduated from Campus Law Center. And now our sponsors are from Law Center 2. So that is what the Alumni Association is all about. And that's where we look forward to our continued collaborative effort across not only these three centers, we have the fourth center also, which is the 5-year law course. So we look forward to collaborative opportunities being created in the larger interest of the students. And this moot court competition happens to be one such opportunity wherein we connect with our students, and also we create visibility with reference to our endeavors across the entire Indian geographical terrain. God willing, we would also start off with an international venture, but we need to first strengthen our foundation, and only then we can venture into that. But what we also need to understand is that the lawyers who came over to judge, or the semi-final round wherein we had our own alumni judging, the Delhi High Court judges judging the semi-final round, the final round of this moot court competition, again is a tribute to the legacy of the Faculty of Law, that students having graduated from Faculty of Law have marked their presence in different streams, different echelons, be that bureaucracy, be that ministry. So we look forward to keeping our flag at high mast, and that's where such an opportunity and such a venture, having been floated and initiated by Sri R.N. Mittal Memorial Trust, is a welcome step. And I welcome you and thank you for floating and creating that opportunity. And through you, there are 58 institutions getting connected. So communicating across different segments, different institutions, connecting the entire legal student body is a huge step in making available some opportunities at some point of time in their lifetime journey. So thank you very much for giving that opportunity, and sir, we look forward to your continued collaboration. और शायद मैं फिर आगे और कुछ आग्रह कर जाऊं, और आग्रह होगा कि बच्चों से एक संवाद करके, there are lot many small little nuances of litigation and professional life and professional ethics that each one of us needs to learn. And I may not be overshooting my territory if I say that Gen Z, परसों मैंने बहुत सुना Gen Z के बारे में, वो हर कोई चीज़ ना प्रेशर कुकर की तरह जल्दी चाहती है. थोड़ा सा थमने का, थोड़ा सा संभलने का, थोड़ा सा पेशेंस जो है ना, वो हमें कम दिखता है. उम्मीद है आप लोगों से वार्तालाप करके कुछ ना कुछ ज़रूर ठहराव आएगा. इसी उम्मीद और आकांक्षा के साथ बहुत बहुत धन्यवाद मुझे सुनने के लिए और आपका आने के लिए बहुत बहुत आग्रह. धन्यवाद. थैंक यू.
Thank you, ma'am, for bringing life back to this ceremony with your ever-inspiring words. With your warmth and encouragement, you truly guide us budding lawyers always.
We take immense pride in introducing someone who is a distinguished alumnus of Campus Law Center, Faculty of Law, Sri K.C. Mittal sir, a veteran advocate and patron of R.N. Mittal Memorial Trust. With over 5 decades of experience, sir has built an extensive practice across civil, criminal and constitutional law and has represented government and corporate clients before both Supreme Court and Delhi High Court. Beyond courtroom advocacy, sir has actively contributed to the legal fraternity through leadership roles such as the President of Delhi High Court Bar Association and Chairman of the Bar Council of Delhi for 2 terms. Sir, your journey from these very halls to becoming a pillar in the legal profession is a source of immense pride for this institution, and we are truly honored to have you back at your alma mater. We now request you to kindly share your thoughts and address this gathering.
Honorable Mr. Justice K.V. Vishwanathan, Judge Supreme Court of India, Chief Justice Delhi High Court, Honorable Mr. Justice Devendra Kumar Upadhyay ji, Madam Tikku, Madam Dalan, Puneet, Arvind, Pratima, all faculty members, dear students, participants in R.N. Mittal Moot Court competition. should we not know and understand before proceeding further who was R.N. Mittal? The full name was Ramanand. Myself, he was number 2 in the family. I am number 4. He struggled alone. He was a self-made person. His personality was outstanding. If you look at the photograph, you can imagine. And he was maintaining his health. He was orator. He was thorough in his brief, up to the mark. Excellent cross-examination. And I can tell you, there is hardly any lawyer on the criminal side who could beat him. The only thing which happened was, perhaps, he moved High Court a bit late. He was one of the finest lawyers and always submissive in the court, maintaining good relations with the judges, with the opposite side, friends and everybody. In fact, I can share with you, when he came in Delhi in 1960 and joined law. I came in 63, there was in between another brother who too was a lawyer, all because of R.N. He wanted me to be a doctor, as a matter of fact. He got me admission in Sarojini Nagar School in the medical course. But what happened? We're not able to go ahead with the medical course, so shifted to science. When in the law faculty, what happened? 1969, the admissions were closed. There was an agitation. I'm just sharing how things have developed and how the destiny takes place and takes you wherever you are. There was an agitation, as usual in India, it happens. And after the close of admission, 100 seats were increased. The agitation was from the law faculty to the university, the BC office. I was also a participant in that, frankly speaking. And outside the window, when I was just roaming around, the Babu sitting inside said, admission dena hai. So how? Paise jama karao, jao. This is how I entered the law faculty. And then what I used to do was, interestingly, around 1:30, pick up the bus, go to Parliament Street. That's where Bhai was having a chamber. Go there, fill in the bail bonds, learn the basics of legal practice. Wakalatname bharna, bail bond bharna, affidavit karna, all those things, and then you will sometimes go to the courts also. But if you commit a mistake, you will be fired. Hota tha, aksar hota tha, but there were a lot to learn, understand from him. And 1972, when I passed out, then I shifted to Tisazari. Let me tell you, R.N. was so meticulous, he was so dedicated to the profession, and he was so honest in his life. I can share with you 2-3 instances. One, 1980, he was offered High Court judgeship. He said, sorry, no. He never wanted to go. He refused it. And the person who offered was rather surprised that what kind of person he is. Again, he was dealing with an important matter where the commission was headed by Justice J.S. Verma, the Judge Supreme Court of India. There was some mistake committed by his client. He was candid enough, told, my lord, this is what the mistake is. Yes, I accept it. The court appreciated him. Justice Verma had the greatest regard and respect for him. And that's how I could also enter. He recognized that the family belongs to a different person and you can trust them. That's why even I could walk any time in the Supreme Court during lunch or anywhere. But something more happened. And that was the matter was so sensitive which he was dealing. He was asked, there was a call from abroad, Mittal ji, आपको मंत्री बनाए, राज्यसभा दे दें, भाई को जज बना दें, आप छोड़ दो ना. He said, sorry, I don't compromise myself with my profession or dignity. That's what he was, and that's what he did, and that's what he stood for all through his life. That is made Aaron. And I would request Puneet to prepare a whole literature of this. Why? Because the youngsters must also understand. You have to, unless you dedicate yourself to the legal profession, you cannot be a successful lawyer. Unfortunately, what is happening today is, and when we're talking about the present conditions, since I've been, Puneet was once in the Bar Council, I've been there for almost 30 years. Aaron was also elected to Bar Council once, he contested. And he was with Justice Y.K. Sabharwal, who was popularly known as Billu Sabharwal. They're good friends, both of them. But that election was set aside and thereafter he didn't contest. Thereafter I entered. The present position, and we were just talking about this, my Lord Justice, Chief Justice was right, and Justice Vishwanathan also. I am reminded of observations made by Justice Sanjay Kishan Kaul in the court, which was carried out by Hindustan Times, a detailed story on it. And that was, my Lord Justice Vishwanathan would remember from Gujarat, where against the Bar Council of India. And ultimately, if we want the legal profession and the lawyers, those who are aspiring, those who are really serious about the profession, then the observations made by Justice Sanjay Kishan Kaul, I wrote on that basis also a letter, but of course nothing happened thereafter. But since looking at the present condition, we have to maintain the dignity of the profession. Remember, Justice Krishna here, it is not a business. It's a sworn advocate of justice. We have to maintain, and today the trend is commercialization. That is where the serious problem is arising, and unfortunately, of course, Justice Kaul has focused on that issue also. Unfortunately, the number of colleges which have been allowed, the intake in the courts, it must match. We see every day what is happening. We face every day. Yesterday day before there was a question raised, even now, about 3 years, 2 years, and 1 year. But friends, you don't know. A judge sitting on the chair of a judge, he is not an IS or PCS officer. It is not a service, it is not a job. You are doing justice, you have to do justice. You have to deal with two sides, advocates from two sides. You have to deal with the litigant, understand the litigant. You have to deal with the files and bar ultimately. Therefore, you have to ultimately understand the legal profession and how it works and how it moves. Let me end by saying one thing. If the judiciary in this country doesn't survive, nothing will survive. Why I'm saying so? Because there are internal and external challenges today targeting judiciary. And we are going weak on that. No successive government likes judiciary. In 2000, yes, I know. So I feel that we need to interact a lot and work it out. I took this much of time because the Dean Tiku also took interest on these issues. Let us debate and discuss on it with the judiciary and come out with. Thank you very much. Thank you.
Thank you, sir, for being a guiding light in carrying forward the legacy of Senior Advocate R.N. Mittal, sir.
It is a privilege to introduce Mr. Arvind Kumar Gupta, sir, a distinguished advocate on record at the Supreme Court of India and founder of R.N. Mittal Memorial Trust. With over 3 decades of experience, sir has built an extensive practice across civil, criminal, constitutional, and commercial law. Amongst other key positions, sir has also served as the Additional Advocate General for the state of Haryana and as an additional public prosecutor for the government of NCT of Delhi. Notably, he has also appeared as Commission Counsel before the Jain Commission, assisted in proceedings related to the inquiry into the assassination of former Prime Minister Rajiv Gandhi. Sir, it's a privilege to have you here, and we request you to kindly address the gathering.
Good evening, all. I, on behalf of R.N. Mittal Memorial Trust, welcome Honorable Mr. Justice K.V. Vishwanathan, Chief Guest of the function. I also welcome Honorable Mr. Justice Devendra Kumar Upadhyay, Chief Justice of Delhi High Court. I also welcome Dr. Anju Wali Tiku, Dean, Law Faculty. I also welcome Manju Arora Relan, PIC Law Center 1. Mr. K.C. Mittal has spoke a lot about Mr. R.N. Mittal. I will say only few words and I share one experience of Mr. Mittal. Mr. R.N. Mittal was a first generation lawyer. He was resilient, self-made man. He was an inspiration and motivation, not only for his family members, but also for everyone or each one who has touched upon his life. He was born in a small village in Mokuda and rose to become one of the finest criminal lawyers in Delhi. His journey was shaped by great adaptation and self-discovery. He was fondly remembered by all of us as Bade Sahab. His professional journey is an inspiration and has a chapter to hear. In 2001, he assigned me one SLP and asked me to draft the SLP. SLP was from High Court of Odisha. 5 petitioners were there all of them were awarded death sentence. And the facts of the case were, according to me, were very bad. A 75-year-old man married a 30-year-old woman. At the age of 75, he wanted to have a child. 4 years he could not have a child. So as inspiration or as desire to have a child, he came in contact with a tantric. Tantric suggested him that if you sacrifice a 4 or 5-year-old female child, you will be blessed with a child. And that couple sacrificed a 5-year-old child. Session Court awarded the death sentence. High Court confirmed the death sentence. I drafted the petition, sent the material to him, and I said, sir, there is nothing in this case. He said, don't judge the facts. Come after 2-3 days, I'll let you know what is in this. After 3 days, he called me. He said, come, I'm ready with it. After reading the file, and he gave me 3-page note, he said, you incorporate these points in this SLP. And he said, out of 5, 2 will be acquitted, 3's death sentence will be reduced to 10 years, and they will be convicted under 304 Part 2. And after 2 years, incidentally, it actually happened. So that was his conviction. After the matter, what he told me, determination made you to take a plunge in this profession. Never judge your facts. Do the justice to your brief. Whatever will happen, will happen. Do the justice to the brief. With this, what I say is that why we have created this R.N. Mittal Memorial Trust. Me, Puneet, and Pratima were discussing one day that in a profession of a chartered accountancy, we have a concept of articleship. In medicines also, there was a concept of junior residentship, where they get a training for 1.5 years or 1 year, which is a part of a curriculum. When we studied law, there was no concept of a moot court. Maybe at bottom of the curriculum, third year end, that moot court competition. But actually, in law faculty, we have never done any moot courts. So with this idea, to bridge the gap and have a meaningful moot court, we conceptualized this idea to form a R.N. Mittal Memorial Trust to contribute and support the promotional work in the field of law. R.N. Mittal Memorial National Moot Court is the first step towards it. We are happy to inform that approximately 60 teams from all over the country have participated. This Dean Ma'am and Mrs. Manju Ellen has also confirmed the same. The participants have demonstrated exceptional skills, articulate arguments, sharp reasoning, and commendable court etiquettes. Each team brought forward thoughtful perspective, making it truly challenging for our learned judges to arrive at the decision. I also extend our heartfelt gratitude on behalf of the Trust to our respected judges who heard the arguments patiently. Their insightful questions and valuable feedback have enriched this experience for all participants. Your time, expertise, and dedication deeply appreciated. As we conclude, let us carry forward the spirit of advocacy, integrity, and justice that this moot court represents. May this experience inspire you to become not just skilled lawyers, but responsible custodian of the law. I will say only 2 more lines. People will not remember you for obstacle you faced. People will remember you how you emerged victorious. I would be failing in my duty if Trust do not recognize the hard work and the commitment shown by the faculty members of the LC1, Dr. Anju Wali Tiku, Dean Ma'am, Professor in charge, Madam Manju Arora Relan, Dr. Apeksha Kumari, volunteers, students, and executives, committee members. I pay my gratitude to Justice K.V. Vishwanathan, who at a short notice accepted and given his consent to grace the occasion as the chief guest of this function. I also thank, along with Puneet, of Mr. Justice Upadhyay, who at a very short notice, shorter notice of a 2 days notice, accepted our invitation and to grace the occasion. I will congratulate the winners and the participants in this function. Thank you very much.
Sir, we thank you for sharing your experiences with us. It's really one of the best ways to learn about the practical aspect of law. It is now our privilege to welcome Mrs. Pratima K. Gupta, former judicial member of the Central Administrative Tribunal and founder of R.N. Mittal Memorial Trust. Ma'am's distinguished legal career is marked by her extensive experience in adjudicating complex service and administrative matters with fairness, clarity, and judicial wisdom. Her contributions to the delivery of timely justice continue to strengthen the framework of administrative law. Ma'am, the stage is all yours.
Justice K.V. Vishwanathan, sir. As we all know him, Judge Supreme Court of India, Justice Upadhyay, Chief Justice Delhi High Court, the Dean ma'am, the PIC ma'am, the faculty members, and the students. I reconnect to the university faculty of law after 35 years. And the euphoria and the energy that is here is amazing. Let me tell you that the euphoria, not just the energy, it has its own euphoria which takes you a place. It gives you one kind of moment. And let me tell you, students, यहाँ पर जब तक आप हैं इतनी मस्ती कीजिए, जम के मस्ती कीजिए, लेकिन जितनी भी मस्ती करें उससे थोड़ी सी ज़्यादा पढ़ाई कीजिए. And there is a reason for that, because this is a unique profession. Your degree will give you a place to stand. Degree will give you a place to walk. But the confidence and life learning lessons that you will get by this masti will give you wings to fly in this profession. Because the combination of two will only give you place in this profession. Second, our trust is our humble way to celebrate the life of my father, Mr. Mittal, because legends are for life. He has so much to give, which we thought that through this platform we should give it to the end users. When I was in my final year, he gave me my first learning lesson to the profession. He says, now that you're entering the profession, you should respect 4 C's. C as in alphabet C. The first is court, जहाँ से आपको relief लेना है. Second is the client, जिसके लिए आप वहाँ खड़े हैं. Third is the opposite counsel. You may lose, you may win, but you will always learn from him. He is your best competitor and teacher. Nobody will teach you in this profession except your opposite counsel. And finally, the cash, which is the motivation in the profession. Without this, you will not have a place to be there. And then he told me one more advice later on is that this profession, we as counsels and lawyers, we say that there are no problems without solutions. It's only the right book at the right place and the right chapter in the right book to find out and where is the hard work for the lawyers, because the problems that are not solved by any profession are solved by us. So we have a unique distinction as compared to the other professions. So my dear friends, taking forward from here, work hard, enjoy. This is the best place to be because we buy problems for others. We get paid to solve problems. So we ask, एक लास्ट लाइन में कहूँगी कि ये एक ऐसा प्रोफेशन है जो हमें बताता है दुनिया में कितना गम है, मेरा गम कितना कम है. अगर हम हर प्रॉब्लम को इस अंदाज से देखेंगे तो हर प्रॉब्लम को सॉल्व कर पाएंगे. At that note, I would celebrate my father's life and take you forward from here. Best of luck to all the children, all students here who will be entering the profession now on in future. Thank you.
Ma'am, we thank you for your encouraging remarks and for being a constant support through and through the organization of the program.
We are graced today by the notable presence of Honorable Mr. Justice Devendra Kumar Upadhyay Sir, Chief Justice of the High Court of Delhi, a distinguished custodian of the Constitution whose decades of devoted service to the law command our deepest respect and admiration. Sir enrolled as an advocate on 11th May 1991 and built a formidable practice in civil and constitutional law at the High Court of Judicature at Allahabad, including its Lucknow bench. His legal acumen and standing at the bar led to his appointment as the Chief Standing Counsel for the state of Uttar Pradesh in 2007, a position he held with distinction until his elevation to the bench. He took oath as a permanent judge of the High Court of Judicature at Allahabad on 6 August 2013 and was later appointed as the senior judge of Lucknow bench on 28 March 2023. Thereafter, he assumed office as the Chief Justice of High Court of Bombay on 29 July 2023 and presently serves as the Chief Justice of High Court of Delhi, having taken oath on 21 January 2025. We most humbly and respectfully request you, sir, to grace us with your address.